Good afternoon, and welcome to the Appellate Division First Department. Most of you know the spiel I'm about to give. Please ask for the time that you need, not the time that you want, understanding that the time clock is for you, not for us. So if your arguments are great, we might keep asking questions. If not, not so much. So please, ask for what you need, not what you want, so that I don't have to do it for you. Okay, People versus Robert Williams.
Yes, Your Honor, for the appellant, 5-1.
Okay. Excellent, 5-1 and 5. Rosenthal versus Board of Managers.
President, appellant, 10-3.
Respondent?
6 minutes.
Okay. So we'll do 5-2 and 6. Sibley's versus City of New York. You weren't listening. Go ahead. Okay. Let's do 6-2 and 6. And remember, the time is for you, not for us. People versus Junior Garcia. Okay. 5-2 and 5. Martinez versus ITF LLC. Okay. 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 So 5-1, 5-3. Okay. Major World versus Solace.
Appellant, 6-1.
Okay. 6-1 and 6. On-Time Construction versus 329 East 57th Street.
For the appellant, we have 5-2.
Okay.
Respond in 5 minutes.
5-2 and 5. Reclaim the Record versus New York City Department of Health.
Appellant, cross-respondent, by 6-4, Your Honor.
Okay. Is there anyone else here? Okay, you've scared away the respondents, so would you like to submit or ask for a more truncated amount of time?
I can do 3 minutes, Your Honor.
3 minutes it is, 3-0. Who are you here for? You just walked in the nick of time, my friend. Let's start again. Reclaim the Record versus New York City Department of Health. Appellant.
So I will, appellant's cross-respondent with 6-4.
Okay. Okay. 5-1 and 5-1. Okay. People versus Mike Scott. Okay. 5-1 and 5. Triumph Enterprises versus Webster Auto is submitted. Geneva versus Black is submitted. Barrios versus Con Ed is submitted. Giordano versus Giordano is submitted. First case on the calendar, People versus Robert Williams. I'm sorry? Oh, is it? Giordano, is there someone here for Giordano? I'm sorry. I messed up. What time would you like? I didn't notice the timing on the calendar. Okay. Respondent? Time. No. 4-1 and 5. Okay, first case on the calendar, People versus Robert Williams.
Thank you. Good afternoon, Your Honors. Whitney Elliott of the Legal Aid Society for the appellant Robert Williams. While we completely stand by our brief's challenges to the assessment of 30 points under risk factor 1 and to the sexually violent offender designation, I wanted to start today with our request for a downward departure to level 1. And we think several parts.
Wasn't there already a downward departure on this case?
Yes, there was from level 3.
So what is it that is so extraordinary that would warrant a further reduction to a level 1?
So a few responses, Your Honor. First, I would say the court below expressly articulated that it didn't view Mr. Williams that he would even be tempted, much less do something like this again. That was the court below's finding. But I think because The court, in our view, incorrectly treated him as a presumptive level 3, found that it was not, quote, was unrealistic to depart further from down to 1. But the court did make an express observation that it didn't think Mr. Williams would even be tempted to do something like this again. Second is the court also found that because of the facts that certain...
I'm not sure what the basis of that finding was, but you can continue.
Well, I think it was based on Mr. Williams. It goes to our second point here, that the court also found that on the facts here that Mr. Williams was more of a thief than a sex offender.
Except I don't know any thief that carries a switchblade and cuts the seam of a woman's pants in order to finger her buttocks. I don't know any thief that is the mark of their MO.
Well, a few things about that, Your Honor. First, in terms of touching her buttocks, Officer Bartley testified in the grand jury and at the suppression hearing. When expressly asked, did you see her touch her buttocks, he said, no, I did not see that. I saw his hand up and down her thigh. After cutting a hole in her pants, he reached and touched up and down her thigh. That was the officer's testimony in the grand jury and at the suppression hearing.
Is that conduct consistent with what a pickpocket would do, for example, using a box cutter maybe to open a purse or a pocket?
I think so, and I think the arresting officer did here as well, because he expressly testified. He watched the incident happen from close range. He watched Mr. Williams take the box cutter out, cut the hole for a couple of seconds, a couple of up and down movements.
Counsel, I've been here over 12 years, and I have seen not one criminal case for larceny where the defendant took a box cutter and cut into the clothing in order to access pockets or something like that. So no, this is not normal. This is not commonplace.
Your Honor, I would just, Officer Bartley's testimony was...
Well, counsel, let me just ask this question, because I understand the argument that you're making here, and but isn't that the basis that the court used to already reduce it from a 3 to a 2, right? So all of these arguments have been considered. The court, as you indicated, expressly said on the record that he might have seen more of a thief, whatever that, whatever his basis may be, but he already offered the departure for that.
That's true, Your Honor, but so a couple things about that. Number one, in terms of our points challenge, we think Mr. Williams has a right to an assessment of the departure based on a correct scoring of the RAI and a correct presumptive risk level, which we think would be a 2. And second, the court also found that the court didn't think Mr. Williams posed any risk of even being tempted to do something like this again, and that's consistent with the level 1 finding rather than a level 2.
So what would you say are the mitigating factors here that we should consider, which you would say would outweigh what took place?
And that were not already considered and factored into the score and the reduction from 3 to 2 already?
So, well, a couple things. I mean, this court, I think, exercises its independent discretion, so in terms of whether to grant further downward departure. But I think the nature of the offense, the prediction about the absence of any risk of harm in the future, his lack of any disciplinary history while in prison, he successfully completed the low-risk SOCTP program.
But aren't all those things you raised, weren't those already considered by the guidelines?
I don't know that the court's finding that there was no likelihood that Mr. Williams would even be tempted to do something like this again was not taken into account by the guidelines.
But even that statement, that's an opinion based on nothing more than conjecture. There is no way for any of us in this courtroom to predict whether he will reoffend. We can hope. Well, none of us can, and certainly Judge McLaughlin certainly didn't have any greater insight than any other judge.
Fair enough, but I mean that was the court below's finding after having at the hearing and reviewing all the relevant records.
All right.
Thank you, Your Honor.
You'll have time on rebuttal.
Good afternoon, and may it please the court. David Gagne for the people. The defendant was correctly adjudicated a level 2 offender. The Sora court already granted him a downward departure from his presumptive level 3 designation to level 2, and there is no reason to grant him any further leniency given the seriousness of his crime. The defense is trying to pass this off as some kind of failed pickpocket attempt. But that is not what the facts show. What the facts do show is that the defendant's conduct was sexually motivated from the beginning of his encounter with the victim.
Also, how do you deal with the adversary's argument that the lower court has essentially found that he was no risk of reoffending, where a level 1 is a low risk of reoffending?
Your Honor, Justice McLaughlin did make certain statements to that effect, but this court is not bound by that analysis. And there's really, again, the facts do not bear that out. What the facts show is that the defendant's crime was sexual in nature. And I would just, I just want to make sure that it's clear that the record shows that when the victim exited the train, she was screaming hysterically, and she said that the defendant touched her and that he was fondling and caressing her leg and her buttock. So whether or not Officer Bartley saw the defendant touching her buttock, it is very clear from that statement in the record that the defendant did in fact make sexual contact with the victim.
Thank you.
Thank you.
So just, I guess, a couple quick points in rebuttal, Your Honor. Just in terms of whether the record shows that this was clearly sexual in nature, I just want to emphasize that these were police workers at the World Trade Center in a lush worker unit of the NYPD. They watched Mr. Williams, in their testimony, behave like a lush worker for over an hour, going in and walking up and down the subway platform, going in and out of subway cars, not stopping. They watched the whole incident take place and did not intervene, and expressly testified they didn't intervene because they wanted to see if his hand came out of her pants with any property. And when they saw that it didn't.
With any what?
With any of her property. And when they saw that it didn't, that's when they intervened to stop. So I think those are just the facts that I would highlight. Thank you, Your Honor.
Thank you. Okay. Rosenthal versus Board of Managers of the Charleston Condominium. You may proceed.
Thank you. Good afternoon, and may it please the court, Drew Packett from Braverman Greenspun on behalf of defendant and appellant, the Board of Managers of the Charleston Condominium. At the heart of this matter is plaintiff's conclusory and erroneous claim that the board and the individual members of the board neglected and refused to address the alleged plumbing issues in plaintiff's unit.
Can we really reach that issue? This is a pleadings motion, right? 3211A1, A7, we must assume for the purposes of the motion to dismiss the truth of the allegations, et cetera, et cetera. Why hasn't plaintiff, for example, stated a cause of action for breach of fiduciary duty based on the allegation that she made numerous attempts to resolve the plumbing issue and it wasn't resolved, although you folks seem to believe that it was resolved? Aren't those issues for discovery and ultimately summary judgment and trial?
Certainly. So the breach of fiduciary duty claim is one that has a heightened pleading standard. As part of that standard, a plaintiff must demonstrate or allege specific information concerning that alleged breach. Here, there's no allegation of a complaint that was made that was ignored. Here we have a situation.
She could not bathe in her apartment for 2 years. For 2 years.
Well, Your Honor,
That is more than sufficient, counsel. More than sufficient.
Well, Your Honor, the issue again here is that she never put the board on notice, which was in late 2019. And again, that's 1 year after residing in the apartment.
So we should ignore in her complaint that she had made complaints prior to that to the building manager or superintendent, et cetera. I forget his name.
Right. So the issue with that is that this building manager was first introduced in her supplemental affidavit that was offered to address the deficiencies in the complaint. There is nowhere that is mentioned in the complaint about this resident manager or the—
Counsel, we're allowed to consider an affidavit to amplify what's said in the complaint, correct?
Correct. However, and this court has done in the past, and I recited to in our brief, Lebetron v. Weiss, this court can disregard an affidavit that directly contradicts what was alleged in the complaint. And in the complaint,
It doesn't contradict it. I think the affidavit amplifies. So if we disagree with you that it doesn't conflict but amplifies, then you lose?
no, Your Honor, because again, the affidavit in the complaint, plaintiff alleges that the first time she put the defendant on notice was when she reached out to Douglas Elliman, who was the condominium's property managing agent at the time. Okay? And she says during that year, she sent countless emails, countless voicemails, countless communications. However, in her affidavit, she admits that she did not reach out to Douglas Elliman until late 2019.
Wasn't there allegations that she reached out to a Mr. Arafi who told her not to lodge any complaints because he was going to take care of it? I mean, why isn't that allegation enough?
So again, this is something outside the scope and something that
Outside of the scope of what?
complaint. So in the complaint, again, she says that the first time she put us on notice was when she reached out to
Counsel, I understand you saying that, but as my colleagues have pointed out to you, case law is clear that we can consider an affidavit. And in this instance, isn't her affidavit simply supplementing what the complaint says with respect to the issues, the complaints, and really the inaction of the board?
Respectfully, I don't think that it does. I think what it does is it tries to cover up, I don't know if, I guess cover up.
That's an interesting use of words on your part.
Cover up her failure to reach out prior to, or in a time where the board had a meaningful chance to respond. Again, you have a situation here.
But incidentally, the complaint also says that back, I think starting in 2014, the building was on notice through Culligan that there was a problem with the water. There was a report out there. So it's not as if, according to the complaint, which for the purposes of the motion we take to be true, the board was already on notice of the problem.
Well, there's no mention in the complaint about anything with respect to what that report said or what it did. The only report.
You're not aware of a report? Is that made up or what?
There was no, when pressed on our motion to dismiss, she didn't, despite claiming sufficient knowledge of what that report stated, it was not provided.
Well, the report was issued 4 years before she took occupancy. So
Correct.
it is your clients who are in the best position to know what that report says, since it was your clients who had it done.
Well, there's no, again, the report also, then there's no mention from the plaintiff, if that report even is involving or discussing her unit. It has nothing to do with her allegations that were made in the complaint or.
The report talks about contaminated water, correct?
That's the 2020 report. There's a 2020 report that is annexed.
I'm not talking about the 2020 report. I'm talking about the 2014 report that my colleague addressed earlier.
Yeah, there's been no indication what that 2014 report says. It predated her involvement. There's no mention that that report.
And again, only your clients would have that information, right? Because I would imagine it's the board who had that report generated.
I can't speak for the report.
You are not suggesting that a company was allowed to enter your building without the authority of your board, conduct tests of your system without your board knowing about it. You're not really making that argument here, are you?
What I'm making, the argument that I am making is that there is no demonstration of what this report actually says. There's nothing that says that the other unit owners in the building have been complaining.
Is that required?
No, Your Honor,
Okay.
it is not.
So then that's irrelevant. All that matters is that the water coming out of her faucet is toxic.
So
It has chemicals that she cannot bathe in.
So
the water smells. It's green or brown, depending on how long you run it.
Well,
that's what the record shows.
The report does not indicate that the water is toxic. The only positive finding in the report is that there is mild turbidity. Turbidity is cloudiness. And again, that report, the 2020 report that says about that mentions turbidity was generated once plaintiff notified the board of the issue. She notified the board of the issue in late 2019. That report is generated weeks later. And then remedial work, $15,000 of remedial work was performed in order to address the issues in her apartment.
And it didn't resolve it.
Well, after that, there have been no further complaints from Ms. Rosenthal about the conditions in her unit.
Well, apparently, we're still here, so there's obviously an issue, right?
Right, and again, I want to just get, this is a pleading issue, and it is that that the plaintiff did not satisfy their pleading requirement to avoid a motion to dismiss.
Thank you.
Thank you.
All right. You may
Afternoon, Your
proceed.
Honors. Jeffrey Metz for Respondent. Your Honors, if the bench has no questions, I'll rest on my brief.
Counsel, were there complaints made after New York Plumbing was brought in to remediate the problem?
As a matter of fact, they were, Your Honor, in April of 20. And if you go to page 252 of the record, you still see the green water in the bathtub. My friend over here has made several misrepresentations to the court that maybe I should clean up. As the bench pointed out, from when she first came in October of 2018, she had a problem. She dealt with the resident manager of the building who essentially gave her a runaround for a year and then said, I can't fix it. She then reached out to Douglas Elliman. Now, Douglas Elliman made very half-hearted and ineffective efforts to resolve this situation, which, by the way, existed at the time the complaint was made and still exists to this day. It has not been fixed. It has not been fixed. There is a fiduciary duty on the part of the board to fulfill statutory authority, housing maintenance code, multiple dwelling law, also, in addition, the condominium documents. It's their responsibility.
Counsel, is your client the only one complaining about the water condition, or is it your claim that it's building-wide?
I didn't say, no, we're not claiming
it's just in her
that
line?
it's building-wide.
You're saying it's in her line only?
It's in her, well, her line, by the way, Your Honor, is the only line that has the bathtubs, the K line.
That has the what?
Has the bathtubs. It's the only line that has the bathtubs. So this may not affect others. And the half-hearted remedial work that they did was dealing with the plumbing pipes to the master line into her apartment. And whatever they did or did not do, it certainly did not work. And you can see in the record, and I find it almost incredible that my colleague would say that they were not put on notice of it. As you pointed out, Your Honor, way back, even before we even came in 2014, there was a Culligan test said there was a problem with this. They were put on notice. They did nothing. We put them on notice in 18 for a year. They did nothing. Then finally,
Was there a formal, so she dealt with the gentleman who was the building manager?
right, the resident manager.
And was there a specific manner in which complaints had to be filed in this building? Was it just a phone call to this gentleman, or was it some kind of form that had to be filled out?
It's interesting that you say that, Your Honor, because according to the client's affidavit, there is some building line, there's some sort of site that you can put in and notify everybody in the building. And he said, don't put it in there. Don't put it in there. I'll take care of this. So he led her down the primrose path for a year before Douglas Elliman got involved. Now, this, I tell you, this is not complicated stuff.
Does this gentleman still work at that building?
I don't know that. Maybe my colleague knows that. I do not.
So you haven't been able to speak with him or get an affidavit or depose him or anything like that?
Your Honor, we filed a complaint. They moved to dismiss. And it was denied. They put in an answer. And by the way, I mean, this complaint, I mean, let's just go back to, you know, to take my colleague's argument to the full extent would be to reverse decades of settled authority with respect to motions to dismiss. You have to give me the benefit of every inference. Whatever I say is true. If it states any cognizable cause of action, you must find it there. And if there's any defect, and by the way, there aren't any defects in the complaint, it was more than adequately made up by her detailed affidavit. So I would ask you to affirm. Thank you very much.
Thank you. You may proceed.
Thank you. And just one quick thing first, I just wanted to mention another that I didn't get to touch on initially, which was that in addition, the lower court erred because it failed to dismiss each of the causes of action against the individual board defendants. There have been no allegations in the complaint or in the affidavit that address any conduct by the individual board members. Now, going real back to the complaints following the post remediation work. My colleague here cited to April 20th. The unit owner, she was not living in the unit at that time. What happened is that in February—
This was during COVID.
COVID, yes.
That she goes to live with her mother because she can't bathe in her apartment.
Well, I'm not sure I agree
sorry.
with that. But so the thing here is that, again, when the board was put on notice, they did the work in February. Then, after February, she moved out. Then, in April, when they received, it wasn't even a complaint, it was follow-ups from the attorney asking for an update. The attorney was notified. We performed remedial work in the apartment, okay? When she returns, she may experience brief bouts of sediment buildup due to inactivity. However, that will be normal after 5 or so seconds, whatever, 1 or 2 minutes, and that things will proceed as normal. From that moment, when she returned to the unit, till I guess a letter sent by the attorney a year later, there was not a single complaint to the board. As a result, the board was under the impression, well, the issue was addressed. The board responded to the attorney letter and said, look, if you're having issues, please let us know. Contact the managing agent, contact the super, let us know, we will handle it. What happened? Nothing for several more months, and then this action was commenced. If the panel has no other questions, I rest on my papers. Thank you. We ask that
Thank you. Have a good day, gentlemen. Sibley's versus the City of New York. You may proceed.
May it please the court, my name is Amir Benno. I represent the plaintiff appellant Marcia Sibley's in connection with this appeal. It's very simple, this issue. We are arguing that the lower court erred in dismissing both the state and federal malicious prosecution claims.
Counsel, let me just ask you a question about the state malicious prosecution claim in particular. This particular case on appeal to the Court of Appeals, her conviction was vacated. Because of 3030 violations, there was an illusory statement of readiness, correct? Right?
That's correct.
So in terms of the probable cause part of the malicious prosecution, would it be, how should we view that conviction that was later overturned? Should it be a basis for probable cause or not?
No, actually, Your Honor, the conviction at trial and then the affirmance by this court is a nullity, and I'll explain why. In fact, this court actually said such a thing in Jeffries versus Griffin, a 2002 case, that any conclusion drawn from a criminal conviction that was affirmed on appeal and ultimately reversed can't be used for any purpose in a subsequent civil proceeding. The Second Department said the same thing. Second Circuit has said it. I'll also say that—
Have we said it, counsel?
Yeah.
I would call
Jeffries
your
versus—
attention, let me call your attention to the Butler case from last year. Are you familiar with that case?
Yes, Your Honor.
So how is that, I agree with you that it's not on speedy trial grounds.
Correct.
But you could make the same argument that it's a nullity there too.
No, the difference, and again, this applies to the state argument.
About the state claims, yeah.
So we're talking Smith-Harvey, which is the Court of Appeals case that addressed this, carved out an exception. Essentially what the rule is in New York is where Butler had to do with a suppression decision that was ultimately overturned. And then because suppression was, it should have been suppressed.
But same argument. If the motion had been granted, there's no trial. Everything is a nullity after that, right?
Well, everything is, there's two arguments wrapped up in that, Your Honor. Just on Butler, which is a drug case, first, there was no dispute in that case not by the criminal defendant who became the plaintiff, that there was possession of drugs. There wasn't an argument that they weren't drugs or the drugs were planted. The drugs were there.
You're saying
It
that,
was
but we're
conceded.
talking about favorable termination. We're not talking about probable cause.
Well, Your Honor, I'd asked about probable cause, and I'm happy to turn about favorable
Well,
termination.
before you
the
go
question
there,
is.
just finish with the probable cause issue.
Right. So to begin, probable cause was not addressed by the lower court. Okay, that's the first issue. Second, it wouldn't be proper, I submit, for this court to address it on appeal. It's not a purely legal argument, which my adversary submits it is. Probable cause is always very wrapped up in facts.
Absolutely.
And the next thing is probable cause, while generally a conviction there would be a presumption of probable cause. It's not the case, and this court's been clear, the appellate division anyway, and the Court of Appeals, I think it was the second department, has been clear that where the judgment of conviction was obtained through fraud or deception or concealing evidence, that you can't use it to establish probable cause. That presumption evaporates. And getting back to the questions of fact that are always tied up in a probable cause analysis, I would submit to Your Honor that in this case, all the facts have to be drawn in the light most favorable to Ms. Sibley.
Is there any dispute that your client refused to turn over her paperwork?
There is, Your Honor. In fact,
She turned over her license?
No,
When she
Your
was
Honor,
asked?
what she said, that the police officer inquired to turn over the license. She asked the police officer, "Why was I pulled over?" And the police officer walked away. She never once, and there's nothing in the record at all, and if you listen to the 911 recording, you'll see that this is clear. There's nothing in the recording at all, despite what my adversary argues, that she's turned them down or she refused to provide it. She merely said, "Why am I being pulled over?" which is a natural question to
Did
ask.
she turn over her license?
Not before she was arrested from the
Or is that
vehicle.
an issue that maybe goes to the basis of probable cause that might be necessary to go before a jury?
Exactly, Your Honor. I mean, I
Well,
would
even
submit-
assuming you're right, how do you deal with the termination issue? So you say because it's a 30-30 case and not a suppression case, that's a sufficient distinction.
Well, it depends whether we're talking about the federal claim.
I'm talking about the state claims only the state claims.
Okay. So the fact is under controlling law, case cannot be brought again. It was a 30-30 dismissal, as you mentioned, speedy trial. Termination of the prosecution was not inconsistent with innocence. So the 30-30 is a speedy trial. It wasn't, I took an ACD, I had a bargain for agreement, it was an interest of justice dismissal as a mercy function. There was nothing that said, look, you're guilty, but we're going to extend some courtesy to you. This was purely speedy trial, and the law in this case is you have to look at the basis for the reversal, and that here is, it's bare of any indication of guilt.
And in fact, you pointed to that Smith v. Hunter case versus Harvey, where that did deal with the 30-30 issue, and the termination of the action could not be revived, and in fact, that was a favorable disposition. That's what happened, right? And then also, just in comparison to the federal 1983 claims, when we're talking about malicious prosecution, the Supreme Court has given us some guidance on what is a favorable disposition.
Yes, that's correct. So it had been in the Lanning case in the Second Circuit, Your Honor, had said that there had to be an affirmative indication of innocence. And most recently, last year, the Supreme Court said that's just simply not the case. In order to have a favorable termination, all that you need is that the prosecution end without a conviction, which completely eliminates the entire—
But in this case, wasn't there a conviction?
I'm sorry.
There was a conviction in this case.
In Ms.
In
Sibley's
this case, there was a conviction. Went to trial, there was a conviction, and then there was a reversal after the conviction on 30-30.
No, but the ultimate judgment is when it went up to the Court of Appeals, that conviction was overturned. And so under CPL 16060, it's a nullity. All of the proceedings that came before that ultimate conclusion.
So
of the
you're
Court of
essentially saying that this Supreme Court case essentially overturns a lot of our precedent.
It doesn't overturn a lot of the precedent. In fact, I think it's consistent to say that there has to be, you do not have to show an affirmative indication of innocence in order to have a favorable termination. That is what this state has always held. The Second Circuit took a different path for a short spell starting in 2018. The Supreme Court put it back on the same track as New York. So I think...
I need to ask you one question.
Yes, Your Honor.
Prior to going to trial, the case had proceeded on a felony complaint, correct?
Yes.
The top charge being an assault 2 on a police officer,
Yes.
correct? And there were both an assault 3 and an assault 2 charge, both of which, just before, on the eve of trial, were dismissed, correct?
The assault 2 charge was dismissed earlier before trial. The assault 3 charge went to trial, and that charge and the harassment charge she was acquitted of, which indicates, if we are going to look and try to divine what the jury was trying to think, that they did not credit the police officers, at least with respect to those charges.
So you're saying that the assault 2 charge was dismissed prior to the day that trial commenced?
Correct.
Was there a speedy trial motion submitted prior to the date for trial on the misdemeanor?
That's when the speedy trial motion was. So after it was reduced, after, I guess, the 180 days, it was reduced to the misdemeanor, and then it exceeded the 90 days readiness for trial. That's when the motion followed. The prosecution had followed an off-calendar statement of readiness. On the following date, they answered not ready. And it all came down to...
Thereby putting into question the statement of readiness that was filed in the interim.
Correct. And just to get to the trial, had the correct decision been rendered on that 30-30 motion from the inception, there never would have been a trial. There wouldn't have been testimony, and ultimately, there wouldn't be this question.
But again, the same thing could be said about the suppression cases. Had the trial court correctly determined it, had the appellate division correctly decided it, and the Court of Appeals hadn't reversed, there would have never been a trial, right?
This court has recognized a difference in the suppression, like Martinez is a suppression case. Butler is a suppression case.
But I'm just trying to understand what the difference is because in either instance, it's a nullity. There would never have been a trial.
Well, the difference is in those suppression cases is that the criminal defendants never disputed to possessing the drugs or to guilt. So the dismissal
Well, so now we
on the
go back
case...
to probable cause. But that's one element of malicious prosecution, but there's also favorable termination.
There is an actual... Your Honor, may I answer this?
Go ahead. Until I stop you, you keep going.
Thank you. There is one other case that's, I think, more appropriate than Martinez and Butler, and I cite to it in my brief, and I don't, the name is, it's in, I'll come to it on rebuttal, I can tell you the name, but it's in my brief. But essentially what it was is, it was also a suppression case. It had to do with a knife. And but in that case, different than Butler, different than Martinez, the criminal defendant denied ever possessing the contraband, said that it had been planted and that the officer lied. Under those circumstances, where you said the officers lied, there wasn't contraband, or it wasn't mine, those cases, they get to go forward with their malicious prosecution and their fair trial claim. Cases like Martinez and Butler, where they say, I don't dispute that it's drugs. I don't dispute that you found it in my premises. I just challenge the lawfulness of the search warrant, or that there was no reasonable suspicion to pursue me on a map hearing, so that you shouldn't have, but I did toss out the contraband and it was recovered. Those kinds of cases, the courts say, look, there's clear evidence of guilt, and so therefore malicious prosecution is inappropriate. The difference between Sibley's case and those is that from the inception, she has always protested her innocence and always said that none of this had ever happened and that they always were making this story up.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court, Diana Lawless for the respondents. I just want to kind of like give a little bit of a roadmap because we've been a lot of places with this case. I just want to start with the probable cause because that's where the question started, and then just make sure I talk about favorable termination and why we considered the state and federal claims differently. So our argument about probable cause, which as everyone knows is an argument that we have raised for the first time on appeal, we believe that it is,
You raised it below, correct? Because if
We
you
raised
raised it for the first time in appeal, we wouldn't consider it.
we raised a different iteration of a probable cause argument below.
But you raised the
We
argument below?
raised this specific argument about probable cause for the first time in appeal, and we believe it's a pure legal question.
On probable cause, it's almost never a pure legal question because probable cause is, as your adversary pointed out, heavily laden with considering the facts.
I understand that, Your Honor. I think we think this is an unusual case. I think our adversary characterizes this as a collateral estoppel argument, and what we're saying is that the reverse conviction gives a rebuttable presumption of probable cause for the conviction. And there's cases, as one of Your Honors said, this court hasn't held it directly, but on page 50 in our briefs, we point out that the 4th Department and the 2nd Department of So held. And then,
Well, let me just ask this question in terms of the 30-30 dismissal that was given by the Court of Appeals. That was based upon the statement of readiness being illusory. So in fact, this is a trial that should never have happened, right? So if you're going to draw a probable cause from things that occurred during the trial, why should we consider that for a trial that shouldn't have happened?
I think that it's a trial that should have never happened, but it's a statutory speedy trial violation. It has only to do with basically the delay in the prosecution presenting the case about specific evidence here.
It's not just a delay, it's an illusory statement of readiness. There's a difference there.
I understand, Your Honor, but I guess the point I'm making is it's a technical violation. There's a technical reason.
You go.
I go nuts every time I hear somebody say that the right to a speedy trial is a technical issue. It is a constitutional issue of gargantuan proportions. It is what our system is built on.
I very much agree with you, Your Honor, but 30-30 is the statutory speedy trial, which goes beyond the constitutional speedy trial, and the analyses are different. So that's what it is. And it's a 30-30 is what was issued at Smith, Hunter versus Harvey, but I think that goes more to favorable termination. But just to finish up on my argument on probable cause, we think that the existence of the case being tried before a jury it gives a rebuttable presumption of regularity in the finding of a jury based on the evidence that was presented. It was presented with the evidence. I know my adversary says, well, there has to be fraud or deception. All the cases have said you need to put forth evidence of that and not just testimony. But to turn Your Honors to the favorable termination.
Isn't testimony evidence?
Testimony is evidence, Your Honor, but I understand,
So
Your
why
Honor,
are there not issues of fact as to probable cause?
there's no issue of fact it's a probable cause because in the situation where there's a rebuttable presumption, particularly in this state, definitely Dolores Torres versus Jones, you have to put forth evidence, including testimony, that something was fraud, deception, fabrication, not just your word that it didn't happen this way. The courts have made clear on that. You're different.
I mean, I'm listening to that. I'm saying, sometimes the only evidence you have is your word because you're the only one there. She was in a car by herself, pulled over for what she says is nonsense. There was no basis to pull her over. She did what every American citizen is entitled to do when they believe they've been pulled over for no just cause. Why are you pulling me over? And for that, she gets pulled out of her car, thrown on the floor, have her face shoved into the sidewalk or the public street, I can't remember which. But the point is, she has a she gets on 911 and calls an operator and says, I don't know if the guy outside my window is a real cop. This is not somebody who is, flying down the street and being crazy and potentially endangering citizens. She's driving down the street and gets pulled over and gets treated like a common criminal. That's what happened here.
Well, Your Honor, I very much understand your concerns, but in terms of what the plaintiff's testimony is, but we're just talking about the tort of malicious prosecution, its contours, and how a case can be stated, and what the legal process is.
Counsel, with regards to probable cause, are you saying that it's enough to establish probable cause to accept the testimony of the police officers, but conversely, it is not enough to challenge that probable cause to the testimony of the defendant?
No, I'm actually saying that it's the rebuttable presumption comes from the jury's finding of guilt, and that the plaintiff. Aside
from the, let's put the conviction here aside, right? Because there's an argument that it's a nullity, and if it's a nullity, why are we considering it?
And I don't have a probable cause argument.
You don't?
I don't.
Okay, that's what I
don't.
wanted to hear.
Yeah. So I want to just make sure your honors are aware about like what we were talking about favorable termination, why we take a different step on a different analysis on state and federal. So the federal claim is a federal 1983 claim grounded in the Fourth Amendment, and that is why the United States Supreme Court, when it reached its decision in Thompson versus Clark, that anything that ends without a conviction is favorable termination.
But the federal claims there has to be some basis in the state claim, right? That's what the statute says.
So it's very complicated, Your Honor, and actually I would draw you to actually one of the decisions of the Second Circuit that kind of actually got overturned by Thompson, which is Lanning versus, I forgot, the Glens Falls, I believe. That's the New York malicious prosecution tort and the federal 1983 claim kind of have different hooks to them. There has to be an extra hook for the federal claim because it's a federal constitutional deprivation.
Right, that's the Fourth Amendment part of
Right.
it. But in addition to that, there is also a requirement that it has to be grounded in some sort of a state claim. The statute, if you read it, it starts out by saying any actor in violation of state, federal, it goes on to say that.
Right. I understand that, Your Honor, but since the Supreme Court announced this rule specifically for the federal claims, nationwide federal claims, and as Your Honors probably know, like state to state, they are different, that we believe that the analysis that the courts have taken in this state about what constitutes a favorable termination, where there has to be an indication of innocence, still applies. Our arguments are in our brief, but here we do believe that this is this situation where the basis of the overturning of the conviction is for a reason unrelated to the innocence, and it's just like, as Justice Singh was saying, the Martinez case, where everything is a nullity, the conviction is still a nullity, but there still is not a favorable.
But is there a distinction to be drawn whether dismissal was on for 30 reasons or suppression? Is there a distinction between the two?
I don't think that there's a real distinction. It's just that Smith-Hunter happened to be a 30-30. Smith-Hunter explained that there could be reasons why, in broadly, not just 30-30, why there could be something that there wouldn't be an indication of innocence. But Martinez followed that, and I don't think that just because it was a suppression was what made it different. I think that what it was the same thing. The trial court upheld the conviction for sufficiency and weighed the evidence. This court did too in this case. The Court of Appeals reversed for a reason that had nothing to do with the proof at trial. And because of that, because there was proof at trial, you can't say that there was a lack of reasonable ground for the prosecution.
Was there any language in the Court of Appeals decision regarding the proof at trial? I believe that the decision just dealt with the issue upon which they rested and did not, as we typically do, once we find an issue, once we determine an issue once we determine a case on a particular issue, the other issues are not expounded upon.
Yes, just this court, and we put it in our brief. This court listed what the facts were, but this court didn't expound on the analysis.
No, I'm talking about the Court of Appeals.
Oh, the Court of Appeals, right, correct. So the Court of Appeals, I will say, with respect to its reason for finding that there was no favorable termination there, the Court of Appeals said in Martinez, the conviction was reversed not because of her lack of culpability. Indeed, her guilt was proven beyond a reasonable doubt, but because the evidence that formed the basis for the conviction was obtained pursuant to a faulty search warrant. So there, I think it has to be that because there was guilt proven beyond a reasonable doubt, which was the same thing that happened here, and then the conviction was overturned for something other than a finding that the guilt was not beyond a reasonable doubt based on the evidence presented to the jury, then there's not an indication of innocence.
Okay.
Thank you, Your Honors. We ask that you affirm, and Your Honors, I'm sure have noted that we confess error with respect only to the federal 1983 claim and respect only to the assault and harassment charges. Thank you.
Thank you. You may proceed.
Thank you, Your Honor. Just on that last point, it's unclear why the city is, well, I understand why they're confessing error, but I don't understand why they're limiting it to only 2 charges, because there's been a dismissal of all of the charges, and then under
But again, counsel, at least from my perspective, there was a trial, jury heard the evidence, reached a conclusion. I understand you're saying that it's based on fraud, but I haven't seen anything that in the record about the fraud that you purport to claim. I know there's a dispute as to what happened, and now you're saying that, in fact, she was apparently willing to turn over information. I don't know, but anyways, go on.
Your Honor, I was my point on the favorable termination aspect is there's a favorable termination as to all of the claims here, and so the federal malicious prosecution should be remitted back down to the lower court completely, not partially. That's also there is no presumption here of probable cause based on the conviction because the Court of Appeals in Simmons versus Sowers, which I cite in my brief, 282 NY 651, says that where the conviction was obtained by fraud, perjury, conspiracy, or other undue means, that presumption doesn't attach. To your point, Your Honor, as to, well, where's that evidence? The evidence has been submitted in the civil case, both in the 50.
What is the fraud?
Well, I list it on pages
Just tell me.
10 to 11.
Tell it to me like I'm 5 years old. What is the fraud?
First, the officers testified. They didn't just testify. They swore under oath and provided to the district attorney. They commenced a prosecution. Then they testified at the pretrial proceedings and at the trial.
So they lied.
They lied.
Okay.
They lied.
They lied, and that was heard by a jury, and the jury didn't agree with that.
That's not necessarily true. First,
It's not necessarily true. There wasn't a conviction?
there was a conviction, Your Honor, but
So it was based on the fraudulent statements.
where there has been a conviction based on fraud, and the fraud is clear, she was a participant in this incident. So she observed what happened. She has firsthand observation. She can testify as to what in fact occurred. She said she never made, they said she made a left turn from the right lane. She said that never happened. They said that she refused to provide her driver's license to the officers. That never happened. The 911 call supports that. They said that she locked the doors to her car and attempted to roll up the windows. That never happened. They said that she rolled up the passenger side window on Officer Casaza's arm, causing it to be.
She didn't do it?
She did not do that. And by the way,
You mean the window didn't go up?
not on his arm.
Did it touch his body?
No, the window only after he withdrew his arm.
But then again, that would go to the assault charge, and she was acquitted of that by the
Correct.
jury?
Yes, Your Honor. And so the jury heard that evidence, and the jury found the officers incredible when it comes to the assault and the harassment.
See, I'm more concerned about the charges she was convicted on, not the charges that she was acquitted on. And that's where I think we're having a
Well,
disconnect.
she was convicted only of resisting arrest and obstructing of
and
governmental
OGA, exactly.
administrations. They claim that she was kicking and thrashing. They pulled her from the car. She says they pulled her out of the window. She never resisted. She never refused to provide this information that they sought. All of that was make-believe. All of it was provided to the district attorney fraudulently by these officers. They testified falsely about it at the trial. Ultimately, the Court of Appeals reversed. This court, the second department, like I said, and by the way, I found that case that I cited, Smalls versus Collins, which does address Your Honor's question. It says, if what the plaintiff avers is true, this is a case where they charged the plaintiff with, who is the criminal defendant, with having a weapon. And he was convicted, and it was went up to the appellate division. The second department credited the police officers that there had been a weapon on this defendant, credited the police officers that they had stopped him in a public housing building, but said, but because there was no reasonable suspicion to commence the chase after this particular criminal defendant, they had to suppress the weapon. But they credited the officers, and this is what the Eastern District said when it came to favorable termination with respect to there having been a conviction, which addresses Your Honor's point. If what the plaintiff avers is true, that he had no weapon, that he gave no one a weapon, that he made no inculpatory statements, and that he dropped no ammunition, then the officer's testimony to the contrary cannot be used to stamp out the claim before it can take root. A contrary rule would permit a reversed conviction that was based on false testimony to categorically prevent a malicious prosecution inquiry, which is surely not the law's intent in recognizing malicious prosecution as a tort. In this light, the malicious prosecution claim survives. I submit that the same result should attach here.
Thank you.
Your Honors.
People versus Junior Garcia. You may proceed.
Good afternoon, Your Honors. Elizabeth Caldwell from the Center for Appellate Litigation on behalf of Mr. Garcia. May it please the Court. I plan to address the denial of the circumstantial evidence instruction today. The prosecution does not defend the denial of this instruction. So the only question before this court now is whether that erroneous denial was harmless. It was not, and we know that for at least 3 reasons. First, the trial court here specifically told the jury about this instruction, but said it did not apply to the sole count for which he was convicted. So this is...
Counsel, at trial, the court did give the circumstantial evidence charge relating to other counts, and in those counts, the defendant was acquitted, correct?
That's correct, Your Honor, and that's reflected on page 1024 to 1027, so the court can see. This is not a case there where the rest of the instruction, therefore, apprised the jury of this critical point, because the jury was told, don't apply this charge to this count, and then we have a conviction on only that count. The second reason we know, in addition to this kind of odd instructional posture here, is that Mr. Garcia was, as Your Honor said, acquitted of all of the counts of constructive possession. This was the case, or this was the count where Mr. Garcia was found in this apartment. The only inference that the jury needed to draw was that he actually had dominion and control over this apartment. That was the...
Is there any direct evidence connecting defendant to this conspiracy?
No, Your Honor, there's not. And the prosecution has not asserted that on appeal. The trial court found that there was no direct evidence. So I would argue that that's not in dispute here.
Indeed, the trial court said that in granting a circumstantial evidence charge for everything else.
That's correct, Your Honor. That's right.
And counsel, what are we to make of Ms. De La Rosa's acquittal?
Your Honor, you're taking the words out of my mouth. I mean, I think that's another crucial thing here, that this shows that this is not a case where there was overwhelming evidence because of the co-defendant's acquittal on very comparable evidence. This was her apartment, and the prosecution's theory was, this is a stash house. Of course they have dominion and control over it. Their job is to watch out for everything. In the face of that evidence, the trial court found that there were reasons to doubt that she was part of this conspiracy. So too, her name is similarly on this document that the prosecution says is a drug ledger. She's on the document, so is the name Unio. The trial court says, that's not enough. I'm nevertheless going to find that there are reasons to doubt her guilt. So I think that when you look at that acquittal, Mr. Garcia's acquittal on everything for which the instruction was properly given, and then we look at the fact that there is the jury is instructed on this instruction, but then acquits. For all of those reasons, we would ask the court to find that this error was not harmless.
Thank you.
Thank you, Your Honors.
You may proceed.
May it please the court, Brent Yarnell for the people. The main inference establishing defendant's guilt of the conspiracy count was that defendant Junior Garcia was the person named Junior who was captured on...
How many juniors, by the way, were involved in this case? In the
There
ledger,
was-
were there any references to other juniors?
There was defendant Junior Garcia, who was found in Isabel's apartment, obviously. There was Joe Jr., who was the person who was giving money to Fueri for heroin he had bought, who was not allowed into
And in the
Isabel's
drug
apartment.
ledger, there were references to a few juniors, right?
No, the drug ledger, there was just one Unio. There was
Junio,
nobody
so-
else named Junior on the drug
Oh, it was a junior. Just said junior. Did it say Junior Garcia?
It said Unio on the drug ledger.
Junior, excuse me. Does that mean that it was Mr. Garcia?
Well, first of all, it was found in the same apartment as Mr. Garcia. Second of all, I think it's notable that every time Unio's name appeared on the drug ledger, it appeared next to Heradelso, the name Heradelso, who is the person that Junior was always seen in accompanying with in real life every
The case
time.
sounds very circumstantial.
Yeah.
Well,
It's
it
not
is
direct evidence. That's all. Everything you've described is circumstantial.
It is circumstantial, and as this court has recognized, when the circumstantial evidence is direct and compelling, as it is here, the absence of a circumstantial evidence charge is harmless. And I would direct Your Honor's attention particularly to People's Exhibit 96A, which is the surveillance evidence showing defendant with Heradelso and Fueri outside the heroin mill at Joanna's apartment at 8:59 a.m. on May 31st, 2015. You combine that with Fueri's comments.
Let me just ask you this question in terms of your harmless error argument. What other evidence was so overwhelming for Mr. Junior Garcia? Because it seems to me that you're saying he was just found inside this apartment. There were other juniors that were mentioned inside this ledger. There's no specific Junior Garcia mentioned, as my colleague pointed out. So what is the overwhelming evidence that would make this harmless error?
People's Exhibit 18 at page 111 has Fury telling somebody on the phone that he was packaging heroin with somebody named Junior and someone named Heradelso from 9 a.m. to 3 p.m. that day. People's Exhibit 96A is video surveillance from that same day that shows defendant.
Was the arrest done on that day?
He was arrested on July 1st.
So that we have no way of knowing whether there was another junior in the apartment on that day.
Well, the inference...
We have no way of knowing.
You do have a way of knowing.
How?
The inference you would have to say that there was another junior in that
I'm
apartment.
glad you used the word inference.
Which inferences, when they are direct and compelling, can establish defendant's guilt, absolutely. And the inference you would have to draw...
Those are your words, not mine.
Well,
I
those
don't
are this
see this
court's
as
words.
overwhelming and compelling.
Well, if it's direct and compelling, I would say that it's overwhelming as well. And the inference you would have to draw is you would have to say that between 8:59 a.m. and 9 a.m., defendant Junior Garcia left and some other junior appeared to package heroin with...
Or he could have been there already. I don't know. No one invaded the apartment for me to know who else was in that apartment on that day.
Well, it's
So
simply...
we are making a leaping assumption that the only junior that was in that apartment on that day was the defendant. I don't know that because the apartment was not infiltrated that day.
Well, there was nobody else who was captured on the video surveillance standing outside the apartment.
I don't care about outside the apartment. They're not packaging the drugs outside the apartment. They're packaging the drugs inside the apartment,
Yes,
right?
and Fury on People's Exhibit 18 and 111 provides a complete list of people in the apartment. It was Junior, Heradelso, Fury, and he says 2 other people he brought with him. That was the complete list of people in the apartment.
How does the government know that?
Well, that's what Fury's statement was. That's what he said. And, you know, look, we have evidence from both Officer Hernandez, who's an expert on drug trafficking organizations, and also we have evidence from the way that Fury
And all of this evidence seems very circumstantial, so then it brings us back to why wasn't the sufficient charge given, and maybe it's not so harmless of an error.
Well, we could see that the charge should have been given. It's harmless, number one, because we absolutely do know that defendant was the junior who, on May 31st...
You don't absolutely know that. You are surmising that. And you may be right, but there's no direct evidence that you're right, which leads us to the ultimate conclusion that, therefore, a circumstantial evidence charge should have been given on this charge as well. And I find it really hard to accept that it was not harmless in light of the fact that this man gets acquitted of every single other charge.
Well, first of all, I would just like to note that the possession charge was solely about the drugs that were found in that apartment, and so that the evidence of the conspiracy was a lot stronger than the evidence of the acquittal, and that's also important when you think about Isabel's acquittal, because the evidence where the evidence between defendant and Isabel was similar was on the possession charge, but there was a lot more evidence of defendant's participation in the conspiracy than there was for Isabel's, so that's important to think about.
He was in the apartment.
And she lives there.
Yes, she lives there.
One is presumed to know what is happening and what is possessed in one's own apartment. So I would not expect him to have more of a sense of what illegal stuff is in the apartment than the owner of the apartment or the leasee of the apartment.
Well, there I totally agree. My point is that there was a lot of evidence of defendant doing things outside of the apartment related to the drug conspiracy and participating in packaging activities outside the apartment. There was no evidence of Isabel doing anything in the outside the apartment, so that's a major distinction. And also, both the phone calls where Isabel is talking with Fury about contraband in the apartment, Fury has to tell her where the contraband is, which is kind of, I mean, look, I take your point, but it does kind of undermine the idea that she had dominion and control over the things that were in those departments, in that apartment. Just because she didn't know where it is, he had to tell her where it was. I would also note, I think it's really important to know, you know, there's no question there was somebody named Junior who was captured on those phone calls who was a participant.
The problem you have and as I read this as a Latino person, is, you know, we have a lot of juniors because we tend to, it is not, it is quite common to name your firstborn son the same name as the father. And so many Latino households have a junior in their house. I think that is not, that is not a strong point for your fact pattern, because here we have in the record conversations about multiple juniors. And there's no last names attached to these additional juniors.
Yes, my point, I would certainly not argue that sharing the first name alone is sufficient, but my point is that there was somebody named Junior on those phone calls who was a participant in Fury's heroin trafficking conspiracy, and we know that defendant and that person named Junior shared certain characteristics that were just simply highly unlikely to be shared by somebody else. So first of all, they both had ready access to Isabel's apartment. We have photographs of defendant in that apartment at all hours of the day, all times, and we know that the person who Fury was calling and talking about on the phone seemed to always be available.
Essentially, it's inference upon inference upon inference. I mean, that's what you're asking us to make to reach the conclusion that it was harmless.
That's true, and I would look at this court's decision in People v. Schachter, where that's exactly what this court did. I mean, it was basically, it was all circumstantial evidence, but it was an accumulation of facts, and those accumulation together of facts basically together were created a direct and compelling inference. So that's absolutely the way that the test works.
Thank you.
Thank you.
You may proceed. Counsel, you should stay with us. That's okay. You don't want to leave your bag either. Okay, go ahead.
Your Honors, I will cede the rest of my time unless you have further questions.
Thank you so much
Thank
for
you
that.
very
Have a
much.
great afternoon. Martinez versus ITF. You may proceed.
Good afternoon, Your Honors. May it please the Court. Jack Watkins from Coffee Medica for the defendant appellant. This case seems complex, but at its heart, it's quite simple. Summary judgment was wrongly granted, resolving multiple issues of fact against the non-movement.
Counsel, you know, when the case stopped seeming complex to me was when I looked at the dashboard video. And so what is the non-negligent reason for the rear-end collision? I understand that there might be comparative negligence for Camacho, but that's not going to prevent partial summary judgment. So what is the non-negligent explanation?
Yeah, I think it's furnished by our expert, Mr. Scott. I think that what the video shows and all surrounding evidence is that this accident occurred on a very dark road. It was wet, the roadway was curved, obscuring the location of
Your
Camacho's
client
vehicle.
testified that he saw the lights.
Of course he saw the lights,
So
Your Honor.
the only explanation he offered was he could not tell
That's,
if the car was moving or not, that he thought the car was still moving.
that's absolutely correct, Your Honor. If you look at page 1588 of the record.
Oh, I've looked at it.
Right, I assume so. That is the dashboard camera. That's the image he was looking at.
I'm
when he
sorry,
was
that
out.
dashboard camera does not help you. So don't ask me to not believe my lying eyes. That dash cam does not help you, okay?
Your Honor,
So don't ask us to pretend like we didn't see what we saw. There's no pause. He goes straight and hits that car.
well, I don't think that's disputed. That's certainly not disputed.
So that is not an argument that helps you.
Well,
The very reason that that's not disputed is what belies your position, right? Because if you can't see it and he thought that the car was moving, there is a point in that video where it is clear as day that she is a couple of feet away from that truck, and yet he proceeds to plow straight through.
At that point, it's 3 seconds from impact. It's
How many-
too late
how-
to avoid the
10,
collision.
3, it depends. It's like,
No,
like she said, we saw
well,
it.
exactly, Your Honor, it depends.
How many,
If it
no, no, no.
depends.
How many seconds did the driver observe the taillights ahead? Is it 3 or is it 10?
The taillights ahead of him were visible on the
For
still
how many
image for
seconds?
10 seconds.
10 seconds, correct?
Were visible on the still image that he was shown at his
For
deposition.
10 seconds.
Were visible, yes.
So what did he do in those 10 seconds?
In
Other than
those
talk
10
on the phone?
seconds, he continued to operate his vehicle because, as Mr. Scott, our expert, said, that while the lights are visible at 10 seconds, they are not readily identifiable as a hazard.
Hold on a second. You're saying that he said that the lights were visible on the photo that he was shown. Does that mean that he didn't see those lights when he was driving?
It doesn't mean he didn't see those lights when he was driving.
What did he do when he saw the lights? Absolutely nothing.
He continued to navigate his vehicle. That's right, but as he also said...
Counsel, the problem you have is that this is a road with nobody on it except them. So your client had an absolute opportunity at 10 seconds before crashing into the back of this car, could have gotten into the middle lane easily.
I
Had
certainly
more
agree.
than enough time
And-
to avoid this accident.
But I nevertheless...
So what is the non-negligent explanation for not moving over?
As Mr. Scott, my expert, has said, and as Mr. Sala, my human factors expert,
Your
has
expert
said...
ain't gonna save you here, okay?
Well, Your Honor, I'm listening to your point, and I understand it, but I believe my expert should save me. I believe that this is an issue. We are scrutinizing still images and asking whether or not a driver should have recognized this
Why
hazard.
are you scrutinizing still images when we have a video?
Excuse me?
Why are you scrutinizing still images when we have a full-fledged video?
You can absolutely scrutinize the video. It's in the appellate record for a reason. We put it in there. We can absolutely watch it.
So why is your argument based on still images?
My argument
Conceitedly,
isn't
still
based
image
on
is going to
still
be very
images.
different from the video.
My written argument in the papers below is based on still images because that's what I can put into a written argument. I can't embed the video. But we reference the video throughout our papers, both below and on appeal. We absolutely reference the video. We encourage the court to view the video on the first page of our appellate brief and the first page of our reply brief. But our position is that in the light most favorable standard that you are obligated to apply, if there is any chance, even the slightest,
But I think
that a
what we're
juror...
saying here is, yes, you directed the court to the video, and we all watched the video, and so there might not be any possibility that would support your argument other than the fact of what we have seen with our eyes through this dash cam video.
Well,
I mean, in most instances, there aren't actual real-time recordings of an accident, but we have that here. And regardless of how your expert tries to opine on it, the video is what it is.
But again, my expert says that in real time, it would take at least until the 5-second mark for a human being to identify that as a hazard in his lane. In the image itself,
But
it's
it
not
doesn't
obviously
even
in
have
his
to
lane.
be a hazard in your lane, right? Because as a driver, if I'm driving down the road and a car in front of me seems to not keeping pace with traffic, I have to slow down in accordance with that, right? Whether they have hazards on or not. If I see the vehicle in front of me stopping, I have to stop. I don't get to just keep going.
No,
right?
of course, and that's why the
Okay,
crucial point is that...
So here, it doesn't really matter because he says he sees the vehicle.
I
and he
disagree.
keeps going.
I disagree, Your Honor, because you assumed in your question that you posed to me is when you see the car in front of you in your lane, which is not what he perceived, and that is what Mr. Scott has
Did he
substantiated.
ever say anywhere that he didn't perceive it in his lane?
What he said it
I
was...
saw nowhere in the record that your client, I don't care what your expert says because your expert wasn't there. Where does your client say that he saw lights but didn't perceive it to be in his lane of travel?
It's at 163 through 64 and 201 of the record.
And
where
he says
he says that the position of the lights was unclear to him due to the curvature of the road. Yes, he does.
Okay. Also, what we haven't included in this is that the driver was speeding and on his cell phone, right?
It's disputed whether he was on his cell phone. He had certainly been talking to another truck driver, but my understanding is they have radio as well. But yes, he was also speeding, that's true. He testified he thought he was going 55. The dash cam video shows it was about 60. So
On a 50,
it is 50
right?
miles per hour at that area. We do address that. And Mr. Scott, our expert, points out that given the limited time in which he had to react to respond to the hazard, he wouldn't have been able to avoid the accident had he been going at a compliant speed. Plaintiff's expert.
When you say he wouldn't have been able to respond, does that mean he would not have been able to stop the car?
He wouldn't have been able to avoid the accident.
Because there's different ways to avoid the accident.
He wouldn't
And I
have been able to
agree that depending on how fast you're going, there is a formula to figure out, based on your speed, how long it's gonna take for a vehicle to stop, right? But that doesn't, that evidence is not the same on a swerve around.
That's true, but Mr. Scott's evidence was that he needed to have at least.
Not his evidence, his opinion.
He is an expert, and he's a qualified expert to offer that opinion.
But it's an opinion.
And crucially, it was not disputed by Mr. Bellizzi, plaintiff's expert. He did not contest it. So right now, that is an admissible expert opinion that is uncontested, which under the
That we can
authority-
accept or not accept. Like every jury. A jury
No.
can accept or not accept.
Respectfully,
and
no.
experts-
You cannot make the same determination that a jury gets to make as to an expert credibility on this. This is a review of summary judgment. You're actually required to accept it if it's even possible for a jury to accept it. So respectfully, no, your position is not the same as a juror's.
All right. Okay.
Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent Martinez. With your permission, I'm going to truncate my argument. I also obviously urge you to look at that video. It's deadly. And
Do you want to address the argument here about the expert and what your position is to why the expert's affidavit doesn't create an issue of fact?
Sure. So let me give you the easiest reason, and then I'll give you the factual reason in the law. If you ran a search on your computer and you put Brian J. Isaac, summary judgment expert, and conclusory, you'd see how many cases I lost, despite the fact I had an expert. Everybody can get an expert. The expert's affidavit has to be predicated on facts. Mr. Scott's affidavit is not predicated on any fact because the plaintiff, and Judge Manzanet, this is what you were asking, actually never said, I thought the vehicle was stopped on the side. I didn't realize that there was a vehicle there. I thought it was an artifact, or I thought it was red. Here's what they said. Let me read it to you. It's one page, very simple, 167, starting on line 8, going to line 16. This is him. The only thing he says, did you see that car before the impact? Answer, I didn't see that car because that car rear lights was off. We know that's not true. Then he says, emergency light was 2-, even emergency light was off. That is true. Here's what he says. But for me, from far distance, it looks like something moving in front of me, like a car is moving in front of me. His testimony was that he thought that the light was a moving car. If it's a moving car and he rams into it at 60 miles an hour, which his expert says is 10 miles an hour over the speed limit, it's worse than if it stopped. Because, Judge Manzanet, you're right. Vehicles can start, they can stop, and you as the rearward motorist have to act accordingly. One hypothetical, and if you don't have any questions, I'll sit down. You know, this is kind of upstate New York. What if you or I are driving, and we're driving, and a deer stops in the middle of the road? He has a license to hit me in the rear because I'm slowing down for a deer or because I stopped for a deer? It's just not true. And my prima facie case was made by the video and by the testimony, and Mr. Bellizzi's subsequent affidavit was simply designed to counteract the affidavit of Mr. Scott, which was done in opposition. It's not a first-time issue on reply. And under
matter that Mr. Bellizzi gave another affidavit in the Bagels case. They point out that he talked about the importance of blinking hazard lights in that affidavit, and that contradicts his affidavit in this case. Does that matter?
It doesn't contradict his affidavit because the affidavits are completely different. First of all, Mr. Bellizzi never said in the Charles against Bagels case, as you know, that the rear-ending motorist wasn't liable. They sued him. They said he was liable. What he said in the Charles case was that because of the double parking, a 12-foot lane became a 9-foot lane, which then made it difficult to pass. Not this case, where we don't have that. And, Judge Moulton, I'm glad you asked me that. I want to read what Mr. Derrico said about the Charles case in his affidavit in opposition to the Camacho motion. Paragraph 8, I'm quoting word for word. There can be no legitimate comparison to the instant matter occurring in an entirely different surrounding context, and it fails the blush test for plaintiff to assert that, quote, the critical facts in Charles are identical to the facts herein. To the contrary, the difference between the underlying situations are so profound as to be the subject of an aphorism, colon, the two situations were quite literally, quote, night and day. Mr. Derrico was right. You should agree with him. Thanks.
Thank you. You may proceed.
Thank you. Good afternoon. May it please the Court, Stuart Lang, on behalf of Yesenia Camacho, the respondent in action number 2, who joins in the argument of my most esteemed colleague, Mr. Art Isaac, with respect to the lower court's correct decision to grant summary judgment finding the appellants to be liable for this accident. I will not repeat any of the arguments that Mr. Isaac made, but I will address the issue that was raised by appellant's argument that the lower court erred in not finding Yesenia Camacho to be comparatively negligent as a matter of law. The lower court was correct in not declaring Camacho to be comparatively negligent as a matter of law because the appellants, then defendants, did not move for that relief below. The dash cam video, it demonstrates violations of the Vehicle and Traffic Law, sections 1202A1J and 1163E. However, because the appellant did not move for this relief below, the issue of Ms. Camacho's possible justifiable noncompliance with these statutes was not framed for that court, nor was it addressed or briefed. This was not an issue of pure law, a question of pure law that appears on the face of the record that did not involve factual issues. Appellants essentially raised this issue for the first time before this court on a record that is not factually mature. She did not have the opportunity to explain why she might have been justifiably noncompliant with this statute, with those statutes. And if Your Honors have no questions for me, I'll rest my argument.
Thank you.
Thank you.
Just briefly, Your Honors, if I may. The quote that was just read from Mr. Yuldashev was in the present tense. He had just watched the video. He said, it looks like something from far away in front of me. Please consult the record. He just watched the video. So when he's saying, to me, it looks like something that was far in front of me, he wasn't narrating his experience. He was responding to the evidence that he had just been shown. And it's fair enough to say that when you have the privilege of being walked through this video, frame by frame, with frequent pauses to be asked exactly what you could see, it could look like the vehicle is still in your lane and still be ahead of you. But the real question here is whether the failure to observe this vehicle in this lane as a stopped item that was a hazard was a breach of the duty to keep a proper lookout. And in cases in which there's darkness, there's obstruction of sight lines, both of which were present here, as thoroughly laid out by us in our papers, this court has repeatedly found that that is an issue of fact that goes to a jury.
And a full 10 seconds for the driver to change lanes to get out of the way.
Which he certainly would have done had hazard lights been engaged, remedying the obstructed sight conditions that I just referenced, yes.
But that goes to comparative negligence. It doesn't go, it really doesn't give you a defense with respect to liability.
Respectfully, I disagree. It goes to whether he breached his duty to keep a proper lookout, because there is a non-negligent explanation for how he failed to apprehend the hazard. That is our answer to that. And again,
So the non-negligent explanation is what?
the non-negligent explanation is that the nature of the hazard is completely obscured by the dark condition, the light
But
pollution.
it wasn't completely obscured. It really wasn't, but whatever.
Again, even if there's the slightest chance that a juror could agree with us, you are required to reverse.
Thank you. Major World versus Salas. You may proceed.
Thank you, Your Honor. This appeal is an Article 78 from a 21-day trial before the Office of Administrative Trials and Hearings, and probably the largest trial ever conducted in that form involving these types of allegations. The trial presented a substantial amount of issues that ultimately resulted in a $3.164 million fine that is both incorrect as a matter of law and not supported by a preponderance of the substantial evidence, which I have to concede, I'm not really sure what that is. Article 78s traditionally are supported by the standard of whether the determination was supported by substantial evidence. However, an oath, their rules themselves say that they had to prove it by a preponderance of the evidence. This court hasn't had a chance to address what that standard means. The Second Department and the Fourth Department have done it. I'm not sure how it's any different than a
How
traditional.
about we deal with the actual issue?
Okay, so it's sort of important, that issue is important for the biggest issue in the case.
No, the important issue here is why your client thinks it's okay to negotiate with clients in Spanish and then not give them all of the documents related to that sale in a language they can understand.
Okay, so
Why don't we get to,
we can
that's
start
really
over,
the
we
issue,
talk about that.
right?
So this 5-33 is a very limited statute. It only deals with installment contracts. What the position that Oath found and what the position the DCA said was every document that's related to the transaction has to be translated.
Well, doesn't the contract itself refer to documents?
Well,
Does it? Yes or no? I believe I read in the contract.
you're talking about the bill of sale.
Yeah, and it says.
It does say
It
about that.
refers to documents that are related to this sale, right?
That's correct, but
Okay.
but a
So
financing.
is there a reason why those documents, which are referred to in the contract of sale,
are not translated.
are not translated?
The answer is yes. And it's a very simple reason.
Oh, please explain.
Because the banks won't take them. So,
That doesn't mean you can't provide an English copy to the bank and a translated copy to your clients so they understand what they have contracted for.
well, I can, that's probably true, and
Oh, it's absolutely true.
they could do it. I'm not sure what effect that would have, and I don't think.
That Spanish-speaking clients would have the ability after the sale to look through their paperwork and see whether all of their rights are being honored?
I mean, that's what happens during the sale when the individual, the salesperson and the finance people read the documents to them in
Counsel,
Spanish.
we have all bought cars.
Nobody reads anything.
We've all leased cars.
Nobody reads anything.
Right? Actually, I do.
Good.
Right?
Okay.
And if I don't do it on the spot, and I do it on the spot, but if I have a question and I have to follow up with my car company over something, you better believe before I make that call, I'm looking at that contract. So tell me why Spanish-speaking buyers of cars are not entitled to the same thing.
Well, as it relates to the installment contracts, they are. And we're not saying that, we're not saying that they're not, Judge. What we're saying is the nature of the application of the penalty under what the regulation calls for is excessive.
Okay, so you agree with me that your client should have given a translated Spanish version of all the documents that are related to a sale. Your issue is that the penalty was shockingly above what it should be for this infraction.
I would say, I have to say yes and no. The documents that they should have applied are what you would normally see in an automobile transaction. There are documents that we provided to them that are not required for a transaction. For instance, a Carfax form. So we give them a Carfax form, and they can go on Carfax's website if they want afterwards and look at it and see how they want. It's not translated. So those are documents that are not necessary for the transaction. But I agree with you.
I disagree with that. It seems to me that a Carfax document is a very important document to a purchaser of a used car.
I agree. That's why we give it to them.
So it is a document related to the transaction.
Oh, but it's not related to an installment contract, and that's really
Yeah, but it's related to, should I buy this car or not? And should I not, as a only Spanish-speaking person, be entitled to read it?
Well, I mean, and this was litigated pretty extensively. We should stop giving them Carfax because there's nothing in there. There's nothing that says we have to do it.
That argument lays flat here.
But we have no.
That lays flat
I
here.
understand.
So if your clients choose to proceed with their business in that way, that's their business.
They're not doing it. We've now translated all of them. So I'm not. See, but my point really is to the fine as to this.
Okay.
The fine should have been per transaction, not per document. And it says.
Would that provide an incentive to adhere to this?
Yeah,
because it seems to me that if you only get slapped on the wrist with a $1,000 fine, for instance, that easily sounds a lot cheaper than having to hire a Spanish-speaking translator to translate all of the documents that are attached to a car sales transaction, and so that your clients might consider it a cost of doing business to not comply.
I understand where that's coming from. That's what this court said in 1992 in Van Cortlandt.
And it's true.
It may be, but that's not how the regulation is written so ambiguously. What do we necessarily have to determine that we have to translate?
Doesn't it say any document? Like, how should we interpret the word any? I mean, I think there's a dictionary definition for that.
Well, it says any document related to the installment contract.
It says any document related to the agreement.
But the agreement, you got to look to the subsection in front of that. It talks about the installment contract.
And it says, it mentions the installment contract in subsection A. In subsection B, it mentions a consumer agreement, and then it says anything related to that agreement.
That's correct. It only applies to the installment contract. By the way, if you buy a car and you walk in with a bag of cash, you're not entitled to an interpretation you're not entitled to interpret a document.
I recognize that.
That makes no sense whatsoever.
The statute is real clear.
So,
but most people aren't walking into a used car dealership with a bag of cash.
You would be surprised.
Okay.
You would be very surprised.
Okay. You'll have time on rebuttal.
Okay.
You'll have time on rebuttal. And I'll give you an extra minute since we asked you so many questions, okay? To be fair. Go ahead, counsel.
Good afternoon. May it please the court. Chloe Moon on behalf of respondents. Oaths, careful parsing of DCA's charges and
Well, counsel, let me just ask you this question about...
And bring the mic up so we can hear you. Go ahead.
About the regulation. In subsection A, it does reference an installment agreement. Then it goes on to say consumer agreement. Then it goes on to say agreement. How should we read those words when we're talking about any document?
Absolutely. I would say they didn't use contract, they used agreement, and that's broader than just the contract. I'd also point you to the title of that section, negotiations taking place in Spanish. We're talking about the whole negotiation of this sale here. And that rule was intentionally written broadly and is meant to be interpreted broadly. It says any document over and over. And that also goes to whether this should be per transaction or per document. It's meant to be per document. And I'd like to just note that that interpretation is entitled to great deference here. I'd also like to just address my adversary's comment about the fines being excessive here, but simply because they just disagree with the broad scope of this rule does not mean that that rule is ambiguous. It's very clear. It's any document, and it repeatedly says that.
Did the ALJ, when it assessed the fine, take into consideration the history of this business and its prior violations?
Yes, I think on this specific count, they were looking specifically at the number of documents, but as a whole, there are elements where Oath is looking at the history of this longstanding systemic.
And so taking that into consideration,
yes.
is it reasonable then to assess the fine in the manner it did as opposed to the manner in which your adversary is arguing it should have been?
Absolutely, Your Honor. And again,
Why is that?
this goes to the agency deference. Here, oath was required, if a rule is ambiguous, to defer to the agency's interpretation. And here, the agency's interpretation of how to apply and interpret this rule is that it applies to every document that's a part of this transaction.
And am I correct that here, notwithstanding the large fine here, that the oath declined to consider additional violations that weren't even considered? There were, in terms of the advertising, there were additional multiple days of advertising with hundreds of cars advertised on those days, that this fine could have been even larger had oath considered all of the violations.
Yes, Your Honor. So just to start off, DCA had asked for over $30 million in penalties here, and oath only granted $3 million at the end. Specifically as to
take this a little further, could the oath judge have considered license suspensions or revocations?
Yeah, so actually they ultimately, oath decided that it could not suspend those licenses. I think that is not an issue here. That's not something that my adversary has brought up. But yes, that would be an even further penalty that they did not decide to. And that goes to the careful and nuanced parsing that oath really did here, rejecting certain charges and affirming others.
Counsel, a big chunk of change was the 2 single-day violations of the website advertising. Should the ALJ have imposed the maximum $350 penalty in calculating that amount?
Yes, Your Honor. I think if you look at all the conduct here, which you are allowed to look at the surrounding context for the proportionality of these charges, you do have years of misconduct. But even just the sole number of deceptive language on these 2,000 different web pages, that alone gets you to a proportional penalty here. And that is what should be sustained.
I think my colleague's point was that they only fined $50 per ad, as opposed to the $350 per ad that they could have charged.
Exactly. So, so for that reason as well, this was a moderate and carefully parsed decision.
Thank you.
Thank you so much.
Okay. You have I'm going to give you 2 minutes and 45 seconds.
Okay, so I'm going to run through a couple points first. The biggest portion of the fine here, $1.6 million, is completely unsustainable. It was based upon it's a finding of a violation, and we don't have to get into I don't have time to get into why the language wasn't an attempt to waive VTL section 417. It's not, VTL 417's language is right there. But the ALJ determined that she couldn't, based on the record, find that there were a certain amount of violations based on 4 different documents. So she relied on the bill of sale. The problem with that issue was, and this is all of you, and this is the problem with Article 78, you got a video, there's no written transcript, it's all on the video, audio, you'll have to listen to it. It's all over the record that they didn't prove these amount of violations, Judge, they haven't proved them. And what is before you is the 60 bills of sale that the ALJ used as circumstantial evidence to extrapolate the fine.
But I thought that those were based on ads that were on the internet that placed particular language in a box.
That's a different charge. I'm talking about something else.
417.
The biggest portion of this fine is $1.6 million based upon what the court said, what the ALJ said was a deceptive language in the bill of sale.
Okay.
In the record, and there's no dispute about it, the DCA put in 60 bills of sale. Of those 60 bills of sale, 22 of them didn't have the language that the ALJ said was deceptive. So the court's extrapolation based on circumstantial evidence is
I'm sorry,
substantially
counsel. I'm
flawed.
sorry to interrupt you, but this argument, did you raise this precise argument?
100%. If you listen to the audio, audio. It's all over the record, but we also raised it specifically.
You raised it here, no question.
No, we raised it in a post-trial brief.
But no, at the hearing.
At the hearing,
Not at the hearing, did you raise it?
Well, it was a bench trial, so, I mean, the evidence came in and we argued. We didn't stand up and orally argue. She requested post-trial briefs. In the post-trial brief, I can tell you exactly what we said. And by the way, yes, you'll see it all over the record if you listen to it. We specifically said, and I had a lot of points, so you got to give me a second to get to my piece of paper.
Yeah, I'm not going to cut you off in the middle of a sentence. Go
You
ahead.
might.
I will not.
You've done it before.
If you repeat yourself, yes, but go ahead. You're eating up your time with this.
Okay. We specifically said, and I believe it's at page 43 in the post-trial brief, this is exact language. And we say why they didn't prove their claims, and there's an A, B, C, and D. And D says that the bill of sale is not proven by DCA to have actually been included in over 40,000 deal files. So it's right there. We specifically said they didn't prove that that bill of sale that they say was problematic was in each one of these files. And if you listen to the tape, we're fighting about that all the time. The problem is that the ALJ had no other way to get to 33,000 violations because there was a concession that the other documents that she had a problem with weren't in every deal file. They couldn't figure out how many files they necessarily. DCA didn't want to go through all the files. We gave them to them. They didn't want to go through and determine which ones it was, so they said, there's a bill of sale in every one of them, therefore use that number. So that's over half of the fine. To get to your point that you said before, Judge, about the box dealing with the false advertising.
Well, you told me that was a different issue, so.
I'm moving on now.
Okay.
So the advertising claim and yeah, $700,000 for one day on the internet is, I don't think anybody would say that that's a reasonable fine because nobody looks at every one of those cars. See, unlike the decision in Van Cortlandt Park, which was from 1992, that dealt with a print advertising, I think it was in the Daily News, when all the cars are right in front of you, 1, 2, 3, there was 15 cars right in front of you, and you look at all of them, to navigate a website, you've got to click through pages. Van Cortlandt doesn't really apply to an what we have in the internet advertising age. So, and at any rate, the Van Cortlandt court, and I know I'm running out of time, the Van Cortlandt
I want you to acknowledge that you have been going on now for an additional 2 minutes. So I haven't cut you off. Go ahead.
It's coming.
Yes, because you're beyond the time I gave you by
Unfortunately, there's a lot of issues. But if you look at the last paragraph in Van Cortlandt, you'll see they only fined the dealership for one violation based on the border in that. That's exactly what you have here. It's the same thing. It's the functional equivalent.
All right. We'll take a look at that.
Thanks, Judge.
Thank you. All right. On-time construction versus 329 East 58th. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the Court. For the appellants, my name is Scott Benjamin from the law offices of Andreas Vassilatos. This is an appeal from a judgment after trial, which found joint and several liability for the two defendants that remained. The case was dismissed as against the remaining defendants. The first part I'm going to address very briefly is that there was absolutely no basis to impose joint and several liability on the two defendants.
Right, the court even explicitly declined to pierce the corporate veil between the two entities, correct?
I don't believe, the court sort of sidestepped that.
Anyway, there wasn't proof about anything.
There was no proof
toward proving that the corporate veil should be pierced between the two entities.
Right, the only evidence was some vague argument that they occupy the same office space. So really there was no basis to pierce the corporate veil. So at any event, if everything else stands, the judgment would have to be separated between each of the contracts between the respective defendants. But I think the real key to the appeal here is that the court at trial did not follow the rules of evidence, both with respect to the introduction of the contracts and with respect to the introduction.
Would you agree that essentially those are discretionary decisions?
I would not. I would say that there are rules of evidence rather than suggestions of evidence or recommendations of evidence, and if evidentiary standards are not met, there may be in certain cases close calls, but I don't think that's what we have here. With respect, for example, to what has been described as the summary, which was referred to as Exhibit 8, there was a document that the plaintiff's chief witness, Mr. Chen, used that allegedly summarized the transactions and summarized the payments. But it's very clear that...
The ledgers now? What are you talking about? The
I'm
ledgers?
sorry?
Are you talking about the ledger?
Well, no, nobody ever described that as a ledger. That was a summary that was prepared in connection with...
It was prepared by his wife, right? That document.
I'm
sorry. It was prepared by his spouse.
By his spouse.
What, isn't that a ledger that was prepared?
Well, I mean,
that's how I viewed it when I was looking over the record.
Well, I would say that a ledger would be something that would be prepared in the ordinary course of business on an ongoing basis.
A wife?
That's not what was done here.
A wife couldn't get the information from the husband and put the information down
Well, when he described the manner in which he gave the information to the wife, he kind of picked the numbers out of his head, picked the numbers out of the air.
Doesn't that go more to the weight than...
I'm sorry?
Doesn't that issue go more to the weight than admissibility?
The document was offered into evidence not as a ledger, it was offered in as a summary. And in order for a summary, the courts can permit summaries to come into evidence at trial, but there are specific circumstances. There should be a business records foundation. I would submit that because it's his wife preparing it, she doesn't have that.
Why? Based on my review of this is kind of like a mom and pop operation. It's a small company, right? And not all companies have 50 employees and a administrative staff. Some of these these particular type of companies sometimes are father and son, brother and brother. I mean, that's very
But still,
typical.
there was a case cited by my adversary called People Against Kennedy that talked about the introduction of summaries, and in that case, it was a usurer's diary in connection with a criminal prosecution. But there still has to be, in order for it to be admissible, there has to be some regularity, and the person who makes the entries has to be under some sort of a business duty to make them accurately, in the sense that their job is on the line if they do it wrong. We don't have that here. But in addition to that, what we have is that...
Why don't we have that here? If my husband has a plumbing electricity company, and after a week of work, he says, okay, this week, this is the work that we did, let's create a summary of what my work has been, and she does that for him, why is that not a business record?
If you and your husband do that in connection with every transaction, it may be, if that's your regular process. There was absolutely no indication that this was the regular process and that they only did it with respect to this particular...
Was there an indication one way or the other that this was only done here?
The proponent of the document has the burden of proving that it was made in the regular course of business by individuals who did it regularly. And
well, I would imagine there was a cross-examination here on this issue, right?
there was I believe there was voir dire on that. And
I would imagine cross as well, right? Before the non-jury trial.
On the voir dire, what the witness, Mr. Chen, said when he was asked how he came to the numbers that he told his wife to write down in this chart, in the summary, he said he didn't do it by looking at the contract. He did it by remembering the approximate size of the units that were being renovated, and based on the square footage, he came up with a number and he wrote that down. So in other words, he picked numbers essentially out of the air based on some kind of estimate or factor that he worked out in his...
That sounds like the computation is based on a per square foot basis or something like that.
Well, but in other words, there's a contract. The contract provides a price. If
Did
the husband then...
did the defendant submit those contracts into evidence?
I'm sorry?
The contracts that you're speaking of, were they, how did they get into evidence?
Well, that's another part of the appeal, but the documents were introduced into evidence by the plaintiff.
And Did the defendant have copies of the contracts?
The defendant had copies, are you talking
Well,
about?
where do the contracts come from? Were they produced by the defendants at discovery, or was the plaintiffs who produced them?
I believe the documents were produced by the defendants in discovery.
I think that's.
I'm sorry, I believe the documents were produced by the plaintiffs in discovery.
I'm not sure about that.
Okay, but the plaintiff gave testimony to the effect that he had signed at least some of the contracts at the construction site, and then sort of lost track of where the signed copies were. And one of our chief concerns as an evidentiary matter is that if there existed multiple versions or copies of the contract, because typically in a contract, they get exchanged back and forth, people add in riders, people write.
Well, wouldn't you have all those contracts?
Exactly.
Not necessarily, no.
Well, did your client look for the contracts, and was it accurate to say?
Ultimately,
Hold on. That your client was unable to find the contracts, correct?
I'm sorry.
Your client looked for the contracts and was unable to find the contracts, correct?
Right, but it's the plaintiff's case, and the plaintiff has to introduce the contracts.
And the plaintiff did introduce the contracts, which I understand came from the defendant. Is that correct?
I don't want to misspeak, so if that's how your understanding of the record is, then I don't want to misspeak.
Well, we can clarify, too, for the adversary.
You'll have time on rebuttal.
All right.
Okay?
Thank you.
Good afternoon, Your Honors. Arnold DeJoseph for the plaintiff respondent. Let me deal with the ledger first. If it walks like a duck, he's calling it a summary. In essence, it's a ledger. And as far as Mrs. Chen, if you look at her involvement with the business, it isn't just working on this ledger. If at page 248, 253 to 254, 304, 326, 327, 346, 347, 376, and 410, she was translating. She was doing emails. She was talking to Mr. Croman, the defense witness in the case, during the projects. And at the end of the day, if you look at the plaintiff's testimony regarding this ledger, he specifically says, this is something I prepared in the regular course of business, and I brought it in. And by the miracle of the world, he was able to put the right amounts that are in the actual contracts into the ledger.
So could you address the issue of the contracts? Where do the contracts come from?
Judge, I was looking that up to try and get an answer for everybody. And there was in the record, and I haven't found it yet, and I was trying to find it, but both sides exchanged documents. And I guess there's an exhibit list on page 89 that I was turning to when you spoke, so let me take a look at it.
It's okay, counsel. Don't.
I mean, Mr. Chen did testify that he got the contracts from the defendant, right?
He testified specifically that he was given the contracts by the defendants. And it's amazing because they let the first contract into evidence without objection. And then all of a sudden, I think a light bulb went off, and they objected to every contract then. The judge sitting there, these contracts are exactly the same, literally. Everything is the same except the payment price, which some of them are the same, the apartment numbers, and the dates of completion. Some are blank and some are in there. If you look at every one of them, you read it, I painstakingly did it, they are exactly the same. So this idea that this trial judge, he knows there's a contractual relationship. The parties are admitting to the contractual relationship. The defense is relying on the contracts to raise defenses during the trial about condition precedent and specific performance, and somehow they expect the trial judge to go, you know what, these are none of the contracts. And one of the problems the defense has here is their complete lack of producing one document at the trial to back up anything that they testified to. So when you come to court and say, oh, he didn't comply with the contract, there's no emails, there's no documents, there's nothing between the parties to say, hey, you didn't complete this, you didn't complete that.
Do you want to respond to the joint and several liability question? Because the contracts were with two specific entities. So, I mean...
I did respond to it in my brief, and I said, well, the way I read that judgment, I wouldn't have done it that way. I don't see it, so I think that the
So
judgment...
you agree it should be two separate judgments for the two
Yeah, there has to be a
separate
separate judgment for each, whatever the
Okay.
defendants, whoever the defendants are for each apartment should have gotten a separate judgment. There is no question about that. I also think that the court was very precise below in how it arrived at this verdict, at its decision, I'm sorry, at its decision, and painstakingly went through the amounts to arrive at it. The court was also specifically said in this case, I find the plaintiff credible. And what he's saying is, to be nice, is he finds the plaintiff credible, hasn't mentioned the defendant. And in these kind of cases, that is accorded great weight. So in this case, unless there's some...
So I think that your adversary's big point here is the admissibility of the contracts, right?
No, but the problem is they charted their own course. Once they let that first contract in, if I'm the trial court, all the other contracts are exactly the same. And they all have the same typeset. In other words, it isn't like somebody's different handwritings are in there with the amounts. It's literally done. It's exactly the same. You could tell whatever device was used to put the amounts of each contract in, where the blank was, and the dates, it's done by the same, whatever machine was being used to put that information in, is the same. So the court was entitled to allow those contracts into evidence because he specifically says there's a contractual relationship here. I'd also like the court to take a look about one of the things they said, since I think the contract should come into evidence, is the condition precedent. They don't plead it in their pleadings. They just say, yeah, there's a condition precedent. That's not specificity. That's a general allegation. They don't say, hey, this is the condition precedent. You had to get sign-offs on the electrical and plumbing permits.
But beyond that, if we were to consider the issue of the condition precedent, your client's response to that is that the defendants here continue to do change orders, which prevented the signing of a completion document if they kept on putting in change orders.
Correct, and to bolster that, the idea that the defendant in his testimony goes, I don't even know if there were ever any sign-offs. And that is incredible as a matter of law, because at that point in time, he was renting out the building. How could he not have the sign-offs and have people living there? It just doesn't make sense.
Thank you. Counsel, you have time at rebuttal.
I looked as quickly as I could during that brief period to see what the origin of the contracts were and whether they were produced in discovery. They were introduced by the plaintiff during his testimony. I believe they were the copies that he brought to court, and that's what he produced. But there was indication that the contracts had been signed, and our point is that if he's producing a contract that is not exactly the same as the one that was signed...
What about counsel's point that there's no dispute here that there is a contractual relationship? You allow the first contract to come in without objection.
Yes.
And at that point, doors open, no? And why should all the other contracts come in? Hold on. There's no dispute here that work was going on.
There's no dispute that work was going on, and there's no dispute that payments were made. But there's also no dispute that there were no sign-offs, which was a condition precedent if that contract is taken at its face value. And
but I haven't, what is the response to the change orders? The constant change orders is what prevented.
In the language of the contract, the language of the contract said that all change orders must be in writing. If the plaintiff wanted to show that there had been a series of change orders that prevented them from getting the sign-offs in time, they would have been obligated to introduce evidence of these written change orders. There were no written change orders, and in order to persuade the court, either the court below or this court, that the change orders, any changes, were of such a magnitude that they made it impossible to comply with the time is of the essence provision and the sign-off provisions, he would have had to explain what they were. Because if a change order was, instead of using silver doorknobs, I want to use black doorknobs, well, that's something that probably would have taken 15 minutes to change, wouldn't have affected the ability to get a sign-off. So he never said what the nature of the change orders were, and certainly never introduced any evidence that there were written change orders. So the court, in terms of assessing that the changes were the reason for the delay, was purely based on speculation because there was absolutely no testimony about the nature of whatever the changes were, and there was certainly no written documents entered into evidence to show that there were written change orders that would establish what the magnitude of those changes were.
Okay, thank you.
Thank you, Your Honor.
Matter of Reclaim the Records versus City of New York. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the Court. I'm Alan Racinas, and I represent the City Appellant's cross-respondents. Your Honors, I'd like to start with the FOIL issue at the heart of this case. There are a couple of reasons that the Supreme Court rightly decided this issue. The first being that Reclaim the Records is asking only for uncertified death certificates, but the agency possesses only certified death certificates. The second issue, the second basis, of course, is the statutory exemption. What you have here is an administrative code provision that originated in legislation back in the 1930s, since been recodified as a local law. But it specifically says that death certificates shall be issued if for a proper purpose. That, in turn, has caused the agency, under its specifically delegated authority under several provisions of the administrative code, to set forth what constitutes a proper purpose and simply flesh out that statute.
Also, counsel, determining proper purpose means looking at the content of the death certificates, correct? Because there's a lot of information in the death certificates.
It means determining what the proper purpose for issuing the death certificate is, Your Honor. Yeah, and of course, that's going to involve both what the death certificates contain, what information they contain, and also what the person seeking the death certificate wants to use it for. And as a way of background, Your Honors, it's worth noting that the agency gets about 360,000 requests for these for records per year, birth and death records, issues about 1 million of them per year. The reason that the latter number is bigger than the former is many requests have requests for multiple records. But that just shows, Your Honors, that these are used by private individuals for private purposes. They're not just sitting there. So, which further underlines the final basis and probably in some ways the strongest basis here for non-disclosure, which is privacy. Because this is a non-enumerated basis for non-enumerated privacy protection, Your Honors, as you know, you balance the privacy interest against the public interest. And the privacy interest here is very clear. What you have is you have records that have detailed information about the deaths of private citizens, their time of death, their place of death, their place of burial, and even their cause of death, at least whether it's natural or unnatural. And in the case of medical examiner certificates, which are about 15% of these records, it has the precise cause of death, what exactly a person died of. And this is information that is protected because, as the Court of Appeals said in the New York Times Co. case, surviving relatives have a protected interest in information about their deceased relatives. And on the other hand,
Does it matter if the records are really old, say 50, 100 years old? Does the privacy interest change?
I think it changes slightly, Your Honor, but it's a difference of degree rather than of kind. And the fact that we're talking about only 50 years ago here is important, or as few as 50 years ago. Because as we said in our briefing, if you are very likely to have surviving relatives 50 years later. You're going to have you can very well have in many instances, particularly if a decedent died fairly young, you'll have potentially surviving parents. Certainly you'll have surviving siblings, surviving children. So all of these survivors have a protected property interest. And the other thing that's worth noting, Your Honors, is the other side of the balance, whereas the one side, the privacy interest, is very weighty. The other side is there's almost nothing in that side of the scale at all, because the public interest here is basically nil. The public interest in government transparency the interest in, as the U.S. Supreme Court said in the Reporters Committee case, in learning about what the government is doing. There's no privacy and public interest here in terms of government transparency, which is the whole purpose of FOIL, as it is of FOIA, which the Supreme Court was looking at. And of course, the two statutes are very similar, and looking at one means it's helpful to look at the other. There is nothing about what the government does in these records. These records are simply about information about, these records simply contain information about the deaths of private citizens. And that's another, for all those reasons, Your Honors, all those reasons supporting the FOIL analysis, that also shows why our decision had a rational basis under Article 78. And, you know, Reclaim the Records and the Supreme Court wants to make an issue of how well we responded to comments that were provided during the notice and comment period. Well, Your Honors, that may be a claim under CAPA, but this is not a CAPA proceeding. They didn't make a CAPA claim. They never have. And so the only issue is whether there was a rational basis, and the privacy concerns, as well as a subsidiary privacy concern arising from identity theft, which is commonly known can happen when vital records are provided or are available or obtained by people who have ill will or wish to be malevolent, is another reason both for the rational basis, that justifies us on the rational basis grounds, and a reason for not disclosing on FOIL. And finally, Your Honors, the Boreali analysis here, the separation of powers analysis here is not even close. What you had here was an incremental amendment to a pre-existing rule under specifically delegated authority. And there is simply...
It just added the number, the categories of family members that would automatically be entitled to it. It didn't create a new category, it expanded an existing one.
That's right, Your Honor, that category being family members, and it simply added additional family members, which was always the intent of this rulemaking process. From the beginning, when the agency gave notice of the rulemaking process, it said that that was the purpose. There were some genealogists who came in and said, well, we think we should be included too. You know, by the way, there's no official license for genealogy in New York State. They themselves say on page 51 of the record that genealogy can be a hobby. So under their rationale, I could wake up tomorrow and say, hey, I'm a genealogist as a hobby. And if we were to amend the rule so that genealogists were included, basically any member of the public could get anyone's death record. And again, we think that that's kind of it's really a not wise rule. It's certainly, there's a rational basis not to do it. And that also, again, properly undergirds our decision under FOIL.
All right, you'll have time on rebuttal.
Yes, thank you.
Okay. Counsel?
Good afternoon, Your Honors, and may it please the Court. Michael Moritz on behalf of the petitioner, cross appellant, Reclaim the Records. I want to begin with correcting some of the things mentioned by the opposing counsel. First, the notion that this involves identity theft, that this involves...
Counsel, look, if records have date of birth, place of birth, full name and middle name, and social security number, that is enough to steal somebody's identity and begin your process.
Your Honor, but the question...
So a death certificate has that information.
But the question is, what about a death certificate from someone who died in 1950, who was born in the 19th century? That's what we're talking about here. And the thing is, what you have to consider, every other county in New York State issues these records. This is unique to New York City. New York City, the Board of Health...
Rather large city,
yeah.
Would you say?
Of course.
So what your adversary sort of teased out, and I thought it was a good point, I'll let you respond to it. Privacy is not just numbers, cause of death, all issues of health, those kinds of things. Isn't a person or a family entitled to keep that information private, even if it's 100 years?
Your Honor, I would say the answer is no, and there are a few reasons. First, the case they rely on involves September 11th, and it involves the intricate calls of people making 911 calls.
Counsel, look, there are serious privacy concerns of the family members of the dead when the cause of death, should it be due to a disease that perhaps insurance companies think follow the family line, right? So if great-grandpa died of heart disease, and then the insurance company can look at my grandfather and find out he died of heart disease too, does that now raise my insurance rates because I come from a lineage of family members who have heart disease? So there are some very real-world implications and dangers associated with revealing this information.
So, Your Honor, a few things on that. First is, I understand your concern, but the city has presented zero evidence. The burden's on them. They have to provide affidavits.
No, the burden is on you. Why does the genealogist have a legitimate purpose for the private records of dead people not at all related to them?
Your Honor, we addressed those. There are 4 affidavits we submitted. And to give you some of the examples, this includes efforts to repatriate military members who died overseas.
How does a genealogist have a greater interest in that than a family member who has the body of a soldier who never came home? How does a genealogist have a greater interest in that than the family member?
Your Honor, the question is not who has...
Counselor, I need you to answer my question.
Yes.
You don't get to decide whether my question is legitimate or not. So explain to me how a genealogist has a greater interest in the example you proposed.
A greater interest than whom? The surviving family members?
Yes.
So objectively, they might not, but that's
They
not...
don't.
But that's
not
the
they might
test.
not, they don't. They have no. You have raised nothing.
Your Honor, we explain in the record, in the 4 affidavits, and throughout the briefing, the reasons why, and it's not just genealogists. There's also an affidavit from David Bushman who explained how he wants this for family members so that he...
So he can get his family
He cannot.
members, right?
He cannot.
He can make an application. What would prevent him from seeking an application for his family's records so that they could be assessed on an individual basis as opposed to changing the rule?
Your Honor, for example, if he wanted to do research into his cousins, that's not permitted under the law. There's no permissibility for a cousin to get a record. There's no permissibility for a step-parent to get a record. That seems like a problem. But this is also separating, for instance, if someone was raised
We're
by...
not dealing with that here. Now, we're not dealing with step-parents or cousins, because they were so aggrieved, they could bring their own action. We're dealing with genealogists at this point, right? That's...
No, Your Honor. So there's two separate components here. One is the FOIL request, and there are only 2 bases under the FOIL request for them to deny access. One is there a statutory exemption, of which there's none? And the second is there an unwarranted invasion of
But they don't have the records that you're requesting.
Exactly.
Your Honor.
Our case law is very clear. 2 weeks ago, we had the same type of issue before this court. And it was very clear that if the agency doesn't produce that record, they are not required to create it. And so they have certified records. They don't have uncertified records, so they don't have to create uncertified records to provide to your clients.
Your Honor, I understand that's what the opposing counsel...
No, that's what the case law says.
Oh, no, I'm saying as to the facts of this case, it is factually incorrect that they do not have the records we're requesting. And to explain, it's in the record.
All right, counsel, no.
Can I just explain where it's in the...
You're out of time, so I need you to wrap up quickly.
Okay, it's on page 182 and 183 of the record. The registrar of the city, Stephen Schwartz, said they digitized all the records in their possession. That means they have digital files on their computers.
Of certified records.
But a record is not certified before someone certifies it. It's a basic it's, for instance, saying that a record.
Counsel, are you disagreeing with me that this agency does not provide uncertified records?
It's their current policy.
They only supply certified records.
It doesn't mean they don't have them. It's like saying, I only will notarize a document for you, but I can look at a document if it's not notarized. I'm still holding the piece of paper, but it's not notarized until I notarize it. And so if I take a picture of a piece of paper and I hand it to you, it's simply still the piece of paper. It hasn't been notarized. And so we explain this in the record. We show in the record what a certified death certificate looks like. And that's not what we're requesting. We're requesting the images. And so what happens is they take the image, they then print it on certification paper and give it to someone when they've requested.
Because they only provide certified records.
As a policy, not as a matter of fact.
Okay. Thank you. Counsel, you have rebuttal time.
Thank you, Your Honor. Let me briefly address the certified, uncertified issue and also note parenthetically that, of course, this is only one basis for FOIL. For our FOIL arguments, our other two bases are the statutory exemption and the privacy exemption. But what you have when you have a scan of an old record, the records from the late 40s to the late 60s that we're talking about here, that was already certified by the registrar at the time who physically signed the physical document. So while it's true that we would then issue if someone were to request one of those records today, we would also print it on the security paper and the current registrar would also sign it. That is, in our view, effectively a double certification. But in any event, obviously they could ask for certified records, and even if they did, we think that the other two bases for non-disclosure are well more than adequate. Justice Daniels, you had a good practical point about the concerns that this FOIL request raises. Let me give you the bench one more. Data integrity. If people know that everyone's death certificate is going to be available to the public, then they will have an incentive to bend the truth or even, in some cases, lie in a good-natured way to protect their private relatives, the privacy of their dead relatives. Let's suppose someone died of an opium overdose. If there's a medical examiner's inquiry, are you going to want to tell the medical examiner that your father died of an opiate overdose? So the agency in its record-keeping capacity has a very strong interest in the integrity of the data that it has. And under what they're proposing to do would create perverse incentives. The other thing I'll note is Reclaim the Records keeps making this argument. They're making it here today. They made it in their briefs that, someone who died in 1950 was born in the 19th century. Well, I mean, first of all, if only that were the case, Your Honors. Obviously, people die when they're 20, people die when they're 5. They're asking for every single New York City resident's record, death certificate, death record for that 20-year period. And even if the person was born in the 19th century, let's say someone was born in the 19th century, died in 1950, and that person at the time had a 5-year-old son. That son is hopefully, with any luck, assuming everything went well in that person's life, still alive. How many people are there like that, Your Honors? How many people are there like that? So, Your Honors, they're just way off base with that argument.
Thank you.
Thank you, Your Honors.
People versus.
He's got more. Across.
Oh, okay.
Your Honors, I would like to direct your attention to
You have 1 minute.
to page 98 in the record, which is a copy of a certified death certificate. I know this from firsthand experience because it's from my own ancestor. The record is from someone who died in the 1950s. If you look at the record, you will see the certification is not from the 1950s. It's dated October 7th, 2009. That's when I ordered it. It has the signature of Stephen Schwartz, the city registrar, at the time that I ordered this. The original document, if you go to the municipal archives, you can see the ones until 1948. The only difference between those and what the city has is simply the fact that the Department of Health has not yet transferred them to the archives. That's in the administrative code. They transfer them over. And so if you look at the books that are at the municipal archives, as I have done and as many others have done, they're not certified documents. It's a book where someone fills out the record when someone died, and that's it. And so the point here is there's a difference. They've made it their policy not to issue uncertified records. It used to be their policy to issue uncertified records, which we cite in our briefs. Either way, that's not what the law is. And what the law is here under FOIL is...
Also, you're past your time. You see your red light. So let's wrap this up.
...is whether there's any basis to restrict access. And that's only one of the two aspects of this case. The other aspect of this case is administrative rulemaking, which unfortunately we didn't get to discuss, which I think the briefs go into at depth, is whether the Board of Health was right in ignoring every public comment. And if that's the law, then it means that there's no point of a notice and comment, period. They ignored the commentary of everyone to create their new rule, and that's not what the law requires. So I will rest, and but I request that the briefs on this, the law is quite clear.
Thank you.
Thank you, Your Honor.
People versus Mike Scott.
May it please the court.
Oh, wait, she can't even get to her seat yet.
Oh, I'm sorry. I apologize.
Now you may proceed.
Thank you. May it please the court, Joseph Nursey representing Mike Scott. The police stop of the car that Mike Scott was riding in was solely for a traffic violation. There was no probable cause that any crime had been committed, nor was there any probable cause that evidence of any crime or a weapon was in the car.
Was there at least testimony that there was an illegal turn without signaling?
Yes, that's the traffic.
So wouldn't that be a basis for stopping the Ford Fusion?
Yes, I'm talking now about the basis for the search itself.
Oh, but first, you agree, I just want to understand, you agree the stop was lawful?
I disagree, that's the first part of the brief, that the police testimony is not credible on that.
So
but assuming, excuse me.
So it's manifestly uncredible is your position?
Yes, yes. I still don't think anyone's determined why they really stopped the car. There was some talk about an illegal turn. There was some talk about parking in front of a fire hydrant. And, you know, the police were stopping the car. The person, you know, they're going to park it where they park it when the police are stopping you. If it's in front of a fire hydrant, then...
My recollection of the testimony, and correct me if I'm wrong, is that the police didn't put on their siren until the car came to stop at the fire hydrant.
I think that was the indication from Santiago's testimony. I'm not sure that the record is that clear, but...
Let's talk about the search, though.
Yes.
You know, we have to grapple with Newman.
Yes.
The facts in Newman, there were a few more facts than there are here, correct? In terms
Yes.
of what they could see inside the car, what Mr. Newman's behavior was prior to the arrest.
Yes.
Would you distinguish, I mean, how do you distinguish Newman?
I think to distinguish Newman because it has exactly what Newman says it has to, you have to have, which is actual and specific danger to the officer's safety and a substantial likelihood of a weapon. And in Newman, Newman attempted to reach underneath his seat after perfunctorily opening and closing the glove compartment. And it was the fact of him reaching under his seat. Well, first, Newman pretended like he was asleep when the police came up. And then once it was determined he wasn't asleep, he then began suspiciously reaching under his seat while he was supposedly searching for paperwork. And so there's the actual, a direct evidence of some sort of reaching for something, which there was not here. There was no evidence that Mr. Scott was reaching for anything. The only...
Also, the windows were tinted in this case, not in Newman, correct?
Yeah, that's correct. But again, it's what the officers knew at the time they conducted the search. And Officer Burpeo testified And it's the only, like, even unspecific thing that might be suspicious. He testified that he saw Mr. Scott reaching towards his waist, but he acknowledged that once he got to the car and the window came down before there was any search, he saw that what the reaching towards his waist was his dinner was sitting in his lap. He had a meal in his lap, and that's what the reaching towards his waist was for.
He had a box of Popeye's chicken in his.
Yes, a box of Popeye's chicken, that's correct. And what you have here is it's a situation where there was no probable cause. So you have to have, under Newman, actual and specific grounds that there's a substantial likelihood of a weapon. And here you had the two occupants of the car had been removed from the car. Mr. Scott got out of the car. He was frisked without incident. He was told to move to the back. Yes.
Let me just add to that. It's more than a substantial likelihood that there's a weapon in the car, right? That's prong one.
Yes.
Prong two, then you need evidence that shows there's an actual and specific threat to the officers.
That's correct.
Is that here?
No, not at all. Not at all.
So his movement to his waist, that doesn't do it?
No, because Burpeo testified that he saw that movement towards his waist was reaching for his dinner, and he said, I didn't know that at first, but when the windows came down, he knew it.
By the way, was a summons issued for the tinted windows?
Pardon?
Was a summons issued for the tinted windows?
Some suspicion?
Summons, a ticket.
Did you get a ticket?
I believe that was ticket 4, but that was not the base. Again, that doesn't talk to the legality of the search, but that wasn't even the basis for the
No, he's asking, did they give him a summons for the tinted windows?
They gave the driver, Ms. McBride, a summons, yes. But that wasn't the basis for the stop. Both Burpeo and
It was the right-hand turn, yeah.
And the judge, in his findings, found that they only noticed that the windows were tinted when they began approaching the car after the stop had already been
Now, there
made.
was some testimony that the car, that the officers may have seen the vehicle the day before.
Okay.
How does that impact anything?
Not at all, and in fact, the court says it didn't impact at all. I believe it's page 71 of the trial, of the hearing transcript. The judge said he did not even consider the issue of the car before, the night before, and that it was irrelevant. Those are his words, irrelevant. That was not part of their consideration, that there was some suspicion that this may have been a car from the night before.
So that prior incident did not heighten the safety concerns of the officers here?
It could not
Could
have.
not.
Could not
Were
have,
the-
because
the,
the judge found it was irrelevant.
The defendants, they weren't handcuffed, right? They were back in the car.
That's correct.
So could the officers have been concerned for their safety about guns in grabbable areas and all that?
Well, before you answer that question, they were standing at the back of the car in the company of a fellow officer,
That's correct.
correct?
Yes. Santiago went into the car, Burpeo stayed behind the car, and there were two other officers.
But no handcuffs, right?
No, that's correct, no handcuffs.
So that there was no way for these two people to go from the back of the car to the rear doors, open them with all these officers around them, and reach for a gun.
Right.
And just to add on to that, the weapon that was found inside a bag that was lifted up, not necessarily something visible. It was lifted up, and then the weight of that, then it was open.
That's right. The gun was not discovered until Santiago moved the purse, realized or said that one side, it seemed awfully heavy to one side, then shined his flashlight into the purse and saw the gun.
Did he open the purse, or did he just flash the light into it?
He said the purse was open, but he was already inside the car when he did it, and he didn't do the flashlight till he had already moved the purse and felt the weight. That was when he did the
Counsel, and
flashlight.
all this happens while the defendant was outside the car in the back with two police officers and after he had been frisked.
Yes.
And nothing found, correct?
That's correct, Your Honor.
Okay, thank you. You may proceed.
Good afternoon, Your Honors, and may it please the
So
court.
counsel, in this case, my understanding is that the court below upheld the search based on concerns of the safety of the police officers. Is that correct?
Yes, that is one of the.
Now, you've heard the questioning. The defendants are behind, police officers all around. There's no way, I guess, these folks can run to the back seat of the car and grab the weapon and do anything with it. What's your response to
Well, Your Honor, I disagree with the idea that there's no way that the defendant or the driver could have opened the door and quickly grabbed the gun, particularly...
Counsel, before we get there, what's the evidence that establishes that there was a likelihood of the presence of a weapon in that car?
Well, Your Honor, it's particularly as the officers turn on the lights, so this is the first time, because these are unmarked cars and plainclothes officers, this is the first time when the defendant and the driver became aware of police presence. So in response to that, we see this movement of the car. This isn't, because the windows are tinted, the officers
You have, in the light most favorable to the people, you have a car that the police cannot look into because of the tinted windows, and the car maybe is moving from side to side. I think that's what the testimony was.
Your Honor, I think both officers testified clearly to the fact that the car was moving.
Okay, so granted, what else do you have?
Yes, Your Honor, we have that...
You know, I gotta tell you, that claim is so incredible, right? That the movement inside the car was so extreme that the officers from outside the car could see an impact on the shock absorbers. I mean, anybody who knows anything about cars would say that is ridiculous on its face, that you might be able from behind the car to say, wow, that there must be a pothole because those shock absorbers just did this. But because somebody's going like this, it moves the car? That just strains credulity. It really does.
Well, Your Honor, I disagree. I think that this isn't a particularly large car. It's a Ford Fusion, which is a sedan. And personally, just from personal experience...
But counsel, so while I agree with my fellow justice here, I'm willing to grant that for you just for the sake of this discussion. So the car's moving, so what?
Well, I think the fact that the car moves in response, which indicates that the passengers inside are moving, the car's not moving on its own, the passengers inside are making significant movements enough to move this car in response to learning that they were in the presence of police, which I think suggests that they were at least enough for the officers to have a heightened suspicion that what they were doing inside the car was perhaps defendant...
Is it enough to go into a full-fledged search?
Well, Your Honor,
I mean, it was a search. It was a complete search. They get these people in the back of the car. They look under the front of the seat. They look underneath the driver's seat. They search the entire car.
The people do not concede that Santiago opened every door of the car. That happened.
How many seconds?
He didn't open what?
That the people don't concede, don't contest. I apologize. The people don't contest that Santiago opened the doors of the car.
How many seconds did the search last?
Santiago testified that the entire search, or from the time that he opened the first door to the time when he reached the back seat where the gun was located, was 5 to 7 seconds.
That's not a measure of constitutionality, is it?
Well, I think that it does go to the constitutionality because the length
So
of
if the police officer went into the car and opened up a locked container under these same circumstances and it took 3 seconds, that's okay because it took 3 seconds?
No, but what I think it indicates for this court is that there was not lifting up of rugs, there was...
No, there was a lifting up of a purse.
Yes, Your Honor.
Now, is there any testimony whether the officer was able to shine his flashlight and look inside of that purse before he moved it?
He did not testify whether he was able to do that one way or the other.
And I still haven't heard from you what is the basis to establish the likelihood of a presence of a weapon in that car.
Yes, well, Your Honor, I believe there's a number of factors that when considered all together, under the totality of the circumstances, justify the limited search.
Shoot them at me quickly. What are they?
I can do that.
Take your time.
Almost
the last case.
The defendant told the driver immediately, he was yelling at her, he was cursing, he told her, don't give the police anything, don't talk to the police.
Counsel, I'm trying to understand why a citizen who, let's say arguably, I get pulled over, I don't think I should be pulled over. Am I as a citizen entitled to be pissed off about that?
You're entitled to be pissed off.
So This guy thinks he's done nothing wrong. He's being hassled by the cops, being pulled over, and he's telling his girlfriend, we didn't do anything wrong, whatever he was saying to her.
Well, Your Honor,
Right?
he didn't even.
That does not equal, I've committed a crime because I'm angry that the police are pulling me over. That doesn't heighten the interaction to probable cause because a citizen is angry about being stopped.
He's of course entitled to his subjective emotional reaction.
Okay.
I would never argue that he wasn't entitled to be annoyed or frustrated.
Okay.
But I disagree that it does nothing to heighten the tension of the encounter, that he's directing the
No, I
driver.
said it doesn't heighten it to probable cause.
I
It certainly heightens the encounter because now the cops are concerned about an angry person. I get that, right?
Yes.
So I'm not even bothered by the fact that in light of his anger, he was frisked. I wasn't bothered with that either. But now once he's frisked and there's nothing, they have obviously looked in the front of the car in order to access both of these people out of the car, right?
Yes, Your Honor.
What other than him being angry and voicing his frustration about that anger and saying, I'm not lowering my window, I didn't do anything wrong, right? Eventually he lowers it.
Well,
What made that? There must be a gun in this car.
Well, Your Honor, first, I would just like to clarify that we're not arguing here that there was probable cause to conduct a full search of the automobile. We're arguing that there's
That's what happened.
Well, Your Honor, it was a brief, limited search.
I don't care how brief it was. If you invade my property without probable cause, that's a constitutional violation, period, whether it takes 2 seconds or 10 minutes.
Well, not under this court's precedent in People versus Torres, or not this court's precedent, but the Court of Appeals precedent in People versus Torres. There is a slightly lower standard than probable cause, which allows a more limited search in
But
certain
the search
circumstances.
wasn't that limited, right? I mean, it would be one thing if he shined the flashlight in and as he testified, the purse was open if he had seen it, but that's not what happened here, right? He picks up the purse, moves it, and then says it's open or opens it, whichever one, and finds a weapon, right? So isn't that beyond just a limited search? That, in fact, is a full search. He's moving things around.
Well, Your Honor, I think it's tailored here to ensuring that there wasn't a weapon within reach.
I'm glad that you used that word, tailored.
Thank you. I think it's tailored to the issue here, which is ensuring that there's not a weapon that's available that the defendant or the driver could reach and use to harm the officer.
So if we get back to Torres, I mean, I think I've asked you now several times in terms of what is the evidence that shows a substantial likelihood that there's a weapon in the car, and so far all I've heard is the car was moving. He was cursing and angry at his girlfriend. He was instructing her not to give the police any information. There's this talk about that he reached for his waist. I don't know how the officers saw that through blackened windows, but whatever, right? And then we have that when the windows do go down, that the officer sees, oh, he has a box of chicken on his lap. But there's another prong, right? And that other prong, as I asked your adversary, is what is the evidence that shows that there was an actual and specific threat to this officer's safety?
Well, Your Honor, under the Court of Appeals precedent in People versus Mundo, there does not need to be specific reference to something that indicates that there's a presence of a firearm to find this standard met.
Instead of weapon.
Or a weapon. As you see the Torres line of
What justifies this limited search is the safety of the officers, correct? This is not a sanctioned fishing expedition, right?
No, Your Honor, it's not. My point is just that there doesn't need to be, for example, in some of the cases, we had seen like for one of the passengers was wearing a bulletproof vest. Like there does not need to be some specific piece of evidence so directly tied to the idea of the weapon.
So are you saying, because it sounds to me then, if we affirm this case, then we are saying that when an officer pulls a car over for a traffic infraction, all the officer has to say is, I fear for my safety, and I can pull the occupants out of the car and do a full-fledged search of the car to ensure that I'm safe.
Well,
It sounds like that's the rule we're gonna give.
Your Honor, I disagree. I would just like to your questions, Justice Rodriguez, I would like to just detail all those factors if I can quickly. In addition to the argument, the window tint prevented the officers from seeing what those previous movements were before the windows came down. And I think I disagree with my adversary's characterization of the record that Officer Burpo acknowledged that it was just Popeye's chicken, because I think he was conceding that he couldn't tell that there was food until he rolled down the window, but I don't think that means he's saying that explains the movements before the windows came down.
He kind of does. He says the window goes down, and I didn't know beforehand until the window came down that he had Popeye's chicken in his lap.
Yeah, I think that he's conceding that he didn't know to the presence of the food, and I think arguably you could read that to the movement to the waist, but you can't read that to the movement of the entire car.
Well, if the food was on the lap, right, and you're seated, then if your hands go down to your waist, it's at your lap, right?
Yes.
Your waist is kind of connected to the lap.
I agree, Your Honor. What I'm saying is I think it doesn't explain away the vigorous movement that occurred in response to the sirens, the lights and the sirens coming on.
Assuming we believe that.
Yes. If I could just briefly also mention that defendant delayed rolling down the window and was questioning why he had to do these things, even before the officers had a chance to even speak to him to say, we pulled you over because the car turned without signaling and you parked at a stoplight or at a hydrant. So even from the get, he was saying, don't
Counsel, the factors that you've just indicated, aren't they equally consistent with a person who is not thrilled about this police encounter that they may feel is unjustified? And isn't it also just as equally possible that they were secreting something else, not a weapon? I just don't see here what is the evidence that it was a weapon that was that was in the car, and what the specific threat to the officers were.
Well, Your Honor, I think in this court's precedent, in People versus Newman, the defendant was pretending to be asleep, then quickly opened the glove compartment and closed it. I don't see how there's any more there than there is here. So I think that's consistent with this court's precedent that
He opened the glove compartment.
Yeah, that's huge.
That's a major difference.
Some people get shot for that.
Well, I disagree that it's a major difference because I think it is different, of course, but what I think is key here is that in Newman, we didn't have the movement of the car beforehand.
You know, in other cases that analyze this issue, we have the one with the bulletproof vest, right? That, I think we could all agree, that's different, right? You pull someone out of a car, they have a bulletproof vest on. People usually have bulletproof vests because they want to stop bullets, right? So that's something. There was another case, I forget the name, where there was a chase, right? They failed to stop, they took the police on a chase, and then when they stopped, they were not compliant. There's none of that here.
Well, Your Honor, I think
that what you're asking us to do is to further water down this test, where it almost becomes what Justice Mansonet said before, where once you have a legitimate stop, that then is open season.
Just open season.
I disagree. I think the officers have to point to specific articulable facts, which here they did.
And I wish they had here, but we've gone through this round and round. I thank you for your argument.
If I could just briefly mention.
Counsel, we've gone 4 minutes over your argument.
Okay.
Thank you.
Thank you.
In our reply brief, we went over all of the car search cases that the respondent argued in support of the legitimacy of the search in this case. And in every single one of them, there were far more dramatic facts that led to the police carrying the search. One other thing, if the police conduct an illegal search for 1 second, it's still an illegal search. But the Santiago's testimony that the search here only lasted 5 seconds is ludicrous. On page 52 of the hearing transcript, he describes the search. He said, I started at the front passenger side of the car, looked underneath the seat, around the areas that someone could reach for, and worked my way to the other side of the car, starting in the front driver's side and then to the rear passenger and rear driver's side. That's a whole lot
It took you more than 5 seconds to read it.
It took more than, yes.
Let me ask you this, what effect or impact does it have on the fact that the officer moved the purse?
It it means that he had to be conducting the search before he discovered the gun. The gun, plain view doesn't matter at all because he couldn't see it outside the car. And then secondly, he went in and conducted.
And he also didn't say that when he opened the back door and saw the purse, that he could see the open purse and the butt of the gun sticking out of it. He didn't say that either.
Exactly, exactly. He was in the car, moving the purse before he ever shined the flashlight in and saw the gun. Thank you.
Thank you. Okay, and last but not least, Giordano. You may proceed.
1 second, Your Honor. Good afternoon, Your Honors. May it please the Court, my name is Ali Hack from the law firm of Warshaw Burstein LLP, arguing on behalf of the appellant, Anthony Giordano. I believe our position is set forth clearly and thoroughly in our briefs, so if the Court has any questions off the bat, I'm happy to answer them. I mean, the issues here aren't too novel or complex, or else I can go right into my summary. I actually had a lot less time than I thought, so I'm going to give the truncated version. So, did the court below act arbitrarily and capriciously by refusing to vacate the default judgment? The answer here, Your Honors, is a resounding yes. Not only did we meet the threshold for vacating a default, but we never defaulted in the first place. We never, ever were a no-show in this case, ever. From day one.
So as I understand the record, your side was in communication with the other side with respect to responses and such, and so it should not have been marked as a default in light of that discussion, correct?
Well, I mean, that's one reason, but there's many other reasons it should have been marked. We filed on...
Also, this is a friendly question.
Yes.
Just so that you're clear. Okay. I've never been attacked for asking a friendly question.
No, I did agree. I did agree, Your Honor. There's much more here, but yes, that's correct. We actually did file on the return date. We filed our papers on the return date, and we were defaulted for doing that. Meanwhile, the other side had defaulted time and time again, and they got a response.
Does it matter that you filed your response with a cross motion?
Sorry, Your Honor, sorry?
You filed, when you filed your response to their motion, it included a cross motion on your part, correct?
It did, Your Honor, that's correct. Yes.
And that typically requires you giving sufficient time for the other side to respond. And so in terms of that, that was something you should not have done.
Well, Your Honor, of course, it would have been preferable to file 2 days before. They served 14 days before. The preference would have been to file 2 days before. But, Your Honor...
If it was just a response, but you filed a cross motion and they were entitled to 5 days to respond to that.
So Judge Bluth, deny the cross motion and take the opposition. That would have been fine by me. I wouldn't have objected to that part. We could have made a motion later. The motion was not that substantive. It was a motion for to punish them for failing to...
I think the point is that that cross motion would have required an adjournment anyway.
So, Your Honor, yes. So the counsel did ask twice for an adjournment after we filed, and it was inevitable they were going to get their adjournment, because had we filed on time, Your Honor, the court would have still had to give them more than 2 days to file a reply in opposition. Right. So it was inevitable they're going to get it anyway. So it's really a distinction without a difference. It's de minimis. It's inconsequential. And Your Honor, the reason that if Your Honor is wondering why the papers were not filed 2 days before, it's simple. The papers that... So we had served document demands on the other side. They didn't respond. We then served the subpoena for the same documents. They didn't respond. They then made a motion to quash the subpoena. That was denied. And when it was denied, they were ordered to produce within 60 days those same exact documents that we needed to post summary judgment. We didn't have the documents in our hands to post summary judgment. So the prior counsel, the counsel below, needed every single second he could get to interview witnesses, to go online to find anything on ACRIS, to get documents that were in storage by the client. And it turns out, Your Honor, the two witnesses that they attached in support of their affidavits in support of summary judgment, they recanted their testimony with our papers. How that didn't get Judge Bluth's attention, I have no idea. But to me, that's huge. When you recant your testimony on summary judgment, there's case law, the case called Picnic, on page 30, I believe 39 of my brief, which says that very thing, that if you raise an issue of fact, default should not be granted.
Okay, you'll have time on rebuttal.
Thank you, Your Honor.
Okay?
Good afternoon, Your Honors. May it please the court, Lucille Furman on behalf of the respondent. To each and every one of you, with all due respect, the whole issue was totally avoided in appellant's argument. Where is his reasonable excuse for not filing?
It was law office failure, is what he said. I think he said law office failure, essentially what you can derive from the papers, so.
You can't just cavalierly say law office failure. There's got to be some good faith. What is that failure? This court knows very well there's many precedent cases as recent as 2022 on this very issue. Now, the lower court, Judge Bluth, did not say default entered, no opposition papers. She wrote a very comprehensive decision, very lengthy. She lays out step by step what went on here. The appellant asked for 2 adjournments after I made my motion.
Counsel, shouldn't there really be a hearing or a trial on the merits of this unfortunate family dispute? And doesn't public policy of this state support something like that?
Judge, in an ideal situation, you're correct, and the courts like to have hearings on the merits, but you can't ignore statutory law.
But look. The point is that they had to get an order to get your client to abide by a subpoena. And then you filed a summary judgment motion before the due date of the subpoenaed material.
Your Honor, that's not correct.
Do not speak out of turn.
Your Honor, that's what they alleged. Those are not accurate facts.
Really?
Absolutely. They served a subpoena. I moved to quash the subpoena, which was denied.
And an order was issued requiring your client to supply
certain items.
And they weren't.
Yes, Your Honor.
Prior to the summary judgment?
A month prior. A month prior. We gave certain items, and I gave the court, in accordance with Judge Bluth's specific ruling, she says if there's any items we are not turning over, to set forth why. And we gave that. Again, appellants, in their motion to vacate before Judge Bluth, they give no excuse, nothing whatsoever, why opposition papers were not timely filed. In addition to, as Your Honor's questioned, you then file a cross motion. I don't care if—
Counsel, just let's talk about prejudice for a minute. Can you articulate some prejudice to your client from this delay, this law office failure?
Yes, Your Honor. In response to that, twofold. One is, if I can then first jump to the second prong of meritorious defense, there is no meritorious defense by the—
The question was, what is your prejudice?
First of all, what's your prejudice?
The prejudice, Your Honor, is twofold. One is, aside from the standard litigation, legal fees, time, my client, Cheers Hotel and Joseph Giordano, sold the building some 15 years ago, 13 years ago. They subsequently took those proceeds by way of an IRS 1031 transfer and purchased other property. Because of the appellant's claim, my client is not free to do what he wants with his property because of this pending litigation.
So the prejudice is the general litigation. You're not claiming any prejudice with respect to the few days delay here in the timely filing, correct?
Specifically, Judge, to a few days delay, no. But why would this court ignore that Judge Bluth wrote a very specific order making a deadline December 15th, and it was ignored? This is during COVID. He didn't even have to go to the courthouse or hire an agency to file papers. All he had to do was electronically upload them, but he ignored the court's ruling.
Well, I don't think that that's what he's saying. I think what he's saying is that there was a mistake with respect to the e-filing, and I think that you would be in a stronger position if, in fact, your adversary was engaging in a pattern of delay, for example. But I don't see anything like that in the record. Am I wrong about that?
I would only disagree with the court in light of the fact that he requested not one but two adjournments of my motion. Judge Bluth gave him the first. She gave him the second. No.
And in the meantime, again, they were waiting for discovery. So I know you want to ignore that and say that that's irrelevant, but that is indeed the subject of an order against your client.
I'm not only arguing it's irrelevant, I'm arguing they did nothing to meet the standard of reasonable excuse. If they needed papers or documentation, they could have said to Judge Bluth, we need a third extension. Or, Judge, I need you to, as they claim, prosecute me for not responding to that subpoena. It was timely responded to. Okay. That's an inaccurate report, and it's just self-serving.
Thank you.
Again, Judge, one final point, if I may.
The red light is on, so.
As to the meritorious defense, they don't meet that either. As the court knows, it's between two brothers. He had prior litigations that he brought against other parties and his mother, all resulted in defendants' verdicts because the appellant is not credible.
Okay.
I'm
Counsel,
asking the court,
stop. That's it.
But
Thank
Judge,
you.
my point,
Thank you. 1 minute.
Thank you, Your Honor. First of all, I'm sorry for jumping out of my seat earlier. This case has been on me for a year, so I'm finally getting.
Counsel, don't waste your minute.
Okay, so I'm sorry, Your Honor, but I am compelled to note, for Your Honors, that counsel did not mention, one, any willfulness on our part, number two, any undue delay on our part, number three, any dilatory conduct on our part, and number four, especially, no prejudice. Under the case law, starting on page 29 of my brief and going for many pages, that should entitle us to a vacature of the default. As for prejudice, the convoluted argument that she gave about we're somehow stopping them or alienating their property, there's no list pendants here. I'm not sure what she's talking about. They can do whatever they want, or if they think it's their property, go ahead, but we're going to chase them for the money that they owe us. And where in the record did they produce a single piece of paper in response to the subpoena? That's a total flat-out lie. They didn't produce anything. And not only that, their time doesn't stop because they filed a summary judgment motion. So they were, by the time we got defaulted, Your Honor, they were 57 days in default.
Thank you. Have a good day.
Thank you, Your Honor.